No, I didn't find it quite worth reading. The meal? Yeah. Yeah, that looks pretty cut and dry.
Very nice tonight. I think it will be a big one.
Lynn, where's that? No, well, she got out of experience. Good evening, ladies and gentlemen. Tonight is a regular meeting of the South Kingstown Planning Board. The date is Tuesday, May 23rd, 2023. The time is 7 p.m. The first item on our agenda is roll call. Susan Axelrod.
Here.
Joe Murphy.
Here.
Paul Jordan.
Here.
Robin Pothier. Elizabeth Karp.
Here.
Peter DiStefano is absent, and Maria Mack is here. Our next agenda item is the consent agenda. This consists of approval of minutes from April 11th, 2023 work session, April 25th, 2023 regular session, and report of the administrative officer, which does include, under actions taken, changes to coastal community structures, Daniel Smith, Roy Carpenter's Beach, Units 17E7, 240 Cards Pond Road, AP 92-1, Lot 9, Site 193, approved on April 19th, 2023. Are there any changes or corrections to the consent agenda?
I have one.
Go ahead, Susan.
So I would like to remove the minutes from April 25th from the consent agenda and maybe ask for some clarification on one section. Of course, it concerns me, but in the middle of Section 5, it says, Ms. Axelrod asked if the town would be open to litigation. Could I ask for some qualifying statement there, because it seems, I'm not sure what it seems, but that wasn't in my intent, I guess I'd like to have more explanation on that section.
Just for clarity, it would have been something stated during the during the meeting, and then stated that way.
So I went back and looked at the video, and I had asked if District 5 were able to change the master plan to accommodate a different use, would other people who had been subject to that master plan and not been able to change the use, would we be liable or culpable? Would we have a problem with other agencies who haven't changed the master plan and didn't know they could and have been abiding by the master plan all these years? And that was my question, is whether or not we were liable for litigation, not maybe open to it, which implies that I think we want to sue somebody.
So you were asking about potential for setting a precedent? Is that what you're saying?
Yes, or whether we were liable for legislation, not, I think the
Madam-
word open for legislation is my problem.
Madam
Perhaps we
Chair,
can make a correction there?
we can review
Yes.
the statements contained in that meeting. We cannot change the context in which they were said. So we will review that specific section and make a correction if a correction is warranted. But if you intended to say it to mean something different, we can't go back and fix that.
Okay, but
We can only correct a statement if the statement was written down wrong.
I agree. But for me to ask our attorney if we're open to litigation maybe implies that, are we willing to sue somebody? You know what I mean? I don't know.
Or you're just saying it was incorrectly?
I just feel like I want some,
Transcribed or whatever.
maybe some context that it doesn't imply that.
Opening ourselves up to litigation.
Yes,
Right.
yes.
We will check the tape and make sure that if it is warranted, correct that.
I have one
Thank
as
you.
well.
Okay, go ahead.
The bottom of the second page for the April 25th meetings, Mr. Jordan, contagion design. I might have said cookie cutter, or I'm pretty sure I didn't say contagion. Thank you.
All right, so we will make that correction and hold those minutes until further correction can be
Thank you.
made. If there's nothing else, would someone like to make a motion to approve the remaining items on the consent agenda?
Motion to approve.
We have a motion from Paul. Do we have a second? Second from Liz. Is there further discussion? Hearing none. All those in favor say aye.
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 Motion carries. Next agenda item is a pre-application for a concept plan for a major subdivision, Meehan Major Subdivision. Is there anyone representing the applicant? Come on up to the mic and state your name for the record, please.
Hi, good evening. My name is Mark Dowdell, Dowdell Engineering. I'm the engineer on this job. And with me here tonight is Nancy and Rick Meehan.
Nancy and Rick Meehan were the owners of the lot, and our goal is to subdivide the lot so that we can build a house for our daughter and son-in-law and 2 grandchildren.
Would you like to give us an overview of the basic concept?
Sure. Right now, Rick and Nancy live at the house that's on AP 74, Lot 42. It's currently about a 4.8 acre lot that fronts on Ministerial Road. As you can see from the plan here, the shared driveway for about 4 or 5 houses,
5 total.
5 total houses comes off of that road. So this whole shared driveway right now cuts through the Meehan's property and then heads to the south there. Right now, the plan basically is to split the lot almost in half into parcel A and parcel B. Totally, it's relatively close to half. Most of the easement for the driveway, it's going to stay existing, is going to be in parcel B. Parcel A is going to keep a little bit of that easement, but we were able to get the 80,000 square feet as required by the overlying zoning for both lots, both resulting lots. And on the proposed plan here, we just have a general building footprint of where the proposed house is. We had an idea of kind of the flattest area. I was trying to think of kind of a good spot for the septic, and that's about it. I mean, the proposed house is going to be sharing the same exact driveway, coming in off of that driveway, so there's not going to be any sort of new curb cut off of Ministerial. And what else? That's pretty much it.
So as you probably know, pre-application is just a very informal stage. It's just conversational in nature.
Yep.
Are you aware of the status of the road as a scenic roadway?
Yes. Yeah.
So you understand that there are buffer requirements, and you'll have to take those things into consideration as you figure out the placement of the house.
Sure. Yep.
It's very good that you're not making another curb cut, obviously.
Yeah. Yeah.
How will the topography of the site impact what you do on the site?
Well, it does. You can see to the southwest of the site there is a pretty significant slope. But as far as the impact, I mean, we do have a relatively flat area. There is a little bit of a hill, almost like a, I don't know, it's like a knoll, yeah. And the plan is to kind of level that out a little bit and try to, help basically have that flattened out a little bit to help facilitate the construction of the house and where the driveway is going to go and everything.
Questions, comments from board members?
Madam Chair?
Go ahead, Susan.
That was me. I just wanted to
Jay, go
clarify
ahead.
something with Mark. Just for clarification, both parcels are going to be, not including the easement, they're both going to conform to the R80 requirements, correct?
Correct, yes.
And I just want to take the opportunity to remind the board that when the house comes in for development, it will come in as a DPR for development within the scenic highway. So this application is strictly basically for the subdivision. When they come in for the placement of the house and the actual construction of the house, they'll have to come back for DPR.
Susan?
Hi, welcome. I just have one comment. So the 50-foot no-cut buffer means there's no cutting in the buffer. And you have the house nestled right up against what may be mature, I think you've got mostly oak trees in the neighborhood. And so and what you choose to do is your choice, but it looks like the house might be 2 or 3 feet from the mature forest, where you can't cut anything in that mature forest. So I guess just be aware that when you are placing your house, that, you know, unless you want squirrels in the attic, you might not want to place it so close to the trees.
Sure. Okay, yeah.
And you also know that the driveway, the garage can't face Ministerial Road.
Right. The one that has to face the front, I mean, basically the front of the, where it fronts on, the driveway, or, you know, not toward Ministerial, because of the scenic highway. Yeah.
Anything else from anyone? They have asked us to combine conceptual master plan and preliminary. We have a motion on page 6 on the staff comments, if someone would like to make that motion.
Maria? One second.
Sure.
Move on.
Just speak up so that the,
Yes. Could we go to the yield plan?
Do we need to
This is the plan that shows the proposed road to show that you can actually subdivide this into 2 parcels. That area that you're proposing that road is a very steep area. It has an elevation change of about 42 feet. That road looks like it's about 200 feet long, so I'm wondering, how are you going to feasibly construct a road with all those restrictions? You have steep slopes along the property line. You have steep slopes going up to the proposed driveway area, and you also have to have a fairly level area leading away from Ministerial Road for the first 150 feet. So I just can't see that location being feasible for a road to actually service any lots on that plan.
No, you're right. I mean, it is really just schematically shown that we can get, I guess, yeah, you're right. I mean, it is a very steep area. Schematically, we were just trying to show that we could feasibly horizontally get the area, but I believe, Rick, had you had a meeting about, I think you and Jamie were talking about a bow tie situation?
Yeah, we originally.
so wait, if someone else is going to speak, just restate your name so that the tape can figure out who's speaking when. Thanks.
Sure, this is Rick Mann. Originally, we tried to not do a variable frontage, and the lot was irregular. And we were told that's probably not a good idea. We're better off if we keep it kind of square and go for the flexible frontage. But the driveway thought is to come in right over that knoll, which is still pretty flat. It's really a pretty small slope coming up that driveway to that point. And then coming in right where that knoll is a pretty flat area. And we are aware of the 40-foot, protection of Ministerial. And we tried to make sure we stayed north of that.
It sounds as though you're well aware of the challenges on this particular site.
Yeah, we are.
Anything else?
It is in the family, so, the house size is going to make sure we fit the house size with the lot. That's the goal.
Very good. Go ahead, Susan.
So I'm going to ask another question. I think I'm going to ask this of staff. If they're trying to build a second house for their family members, would it be appropriate to consider an accessory dwelling on the property that they could then house their family without the struggles of the hillside?
It's the applicant's choice, what they want to propose. Maybe the accessory is not in the desire to do so, and they want 2 separate lots. I think in this instance, what Mark is saying is that when they come back for the next stage and they come back for the combined preliminary, master preliminary review, they provide that level of detail showing that they can reasonably meet that standard for you guys.
Thank you.
Anything else? Would someone like to make the motion?
The South Kingstown Planning Board hereby grants the request of the applicant, Richard Meehan, to combine the conceptual master plan and preliminary plan stages of review for the proposed major subdivision located at 544A Ministerial Road, Assessors Plat 74, Lot 42. The applicant shall be required to meet the application requirements for both the conceptual master plan and the preliminary plan stages of review prior to scheduling the required public hearing.
We have a motion from Joe. Do we have a second?
Second.
Second from Paul. Is there further discussion? Hearing none. All those in favor say aye.
Aye.
Motion carries. Thank you.
Thank you.
Our next agenda item is a public informational meeting, conceptual master plan review, major land development project, South County Commons District 5 Apartments. Is there anyone representing the applicant?
Good evening, Madam Chair. Attorney Matthew Lander on behalf of the applicant, Suffolk Realty LLC and Southern Rhode Island Hospitality. Madam Chair, I'm joined here this evening with Sean Faden, who represents Suffolk Realty, Eric Prevey of Dupree Engineering. Paige Bronk is our land use expert. He's filling in for Ed Pimentel, who submitted a report back in January. I apologize that he couldn't be available. He's come down with something quite serious. He's ill, was unable to be here this evening. Paige and Mr. Pimentel work on a regular basis. They're colleagues. He's independently qualified as an expert. He's read the report and will testify in that regard and answer any questions that you may have. I'm also joined by Paul Bannon, our traffic expert from Beta Group. He submitted the supplemental traffic report again back in January and will testify as to traffic-related issues. I expect to call Mr. Bronk and Mr. Bannon this evening with respect to the land use testimony and the traffic study that has been submitted to the board. Mr. Faden and Mr. Prevey are here to answer any additional questions that the board may have. I know it's been some time since January, our last full official hearing that we had. So they're available to answer any additional questions, but Eric has already testified at length about the project and the plans that were submitted, but we wanted to make sure he was here in case there were any follow-up questions. A bit of housekeeping before I ask gentlemen to come up and testify. You should have all received a binder of exhibits and materials. There was some discussion at the last meeting about all the materials, reports, all the stuff that's been submitted over several months. I know there was a few gaps in between the public meetings. We thought it would be helpful to this board for ease of reference to reorganize everything that's been submitted to date. So I would say about 99% of what's in that binder has already been submitted and made part of the record as of at least January, including all the reports. There was some correspondence between myself and staff and council that we've included. You'll also see a number of historical documents that deal with prior amendments to the South County Commons Master Plan. We believe that that is obviously germane to this application. There was some discussion about the process and procedure for amending it. We included those again for reference as to how the town has treated prior amendments to the master plan, who was required to sign those amendments to the master plan, as well as various amendments to this property and prior approvals for the Fairfield Inn and this existing property and other properties within South County Commons. We just thought it would be helpful to see how those prior amendments have been treated and who signed off on them. You may recall last month, we discussed briefly, or not briefly, but we discussed notice and procedure, and I don't want to recap any of that, but suffice it to say that we have re-noticed certified mail to all of the abutters in South County Commons. We've included the relevant language, comp permit, amendment, and we've also included all of those abutters within 200 feet of the entirety of South County Commons. And that was done, again, out of an abundance of caution, but we did so at considerable expense, frankly, to make sure that every single lot within South County Commons was included and has an opportunity to participate in the proposed amendment to the plan. So I just wanted to note that for the record. We sent an affidavit in, but I have a large stack of the green certified mail receipts if we need to submit those, but that also has been submitted. I don't have anything further. Prior to the meeting, I provided staff with a copy of Mr. Bronk's resume. Given that he'll be providing testimony tonight, you should have received a copy of that. That was the only thing I have distributed
Yes,
prior.
we just received that this evening. Thank you.
Okay, thank you. So I guess that's all I have in terms of housekeeping. I would ask that Mr. Bronk come up to testify and that he be administered the oath, please.
You know, we don't need to swear people in, right? This isn't the quasi-judicial board like the zoning board.
No problem. I'm going to have to share this mic, if that's okay. Mr. Bronk, could you please just state your name for the record?
Paige Bronk, Paige Bronk.
Thank you. Can you please just state your current occupation and place of employment, please?
Community planner, economic development, and community development. My current day job, I work for the town of Groton, Connecticut, as the economic and community development manager.
Okay. Could you just briefly describe your educational background?
Sure. Bachelor's degree, environmental studies in geology, Alfred University. Also a master's degree in community planning and development from the University of Rhode Island. Plus, in addition, American Institute of Certified Planners certification, 1996.
How long have you been in your current position in Groton, Connecticut?
8 years.
Can you generally describe your experience with planning and development related experience, your experience in those fields?
Sure. Overall, I have about 30 years of experience in multiple states. Most of it is in Rhode Island. Over 15 years in Rhode Island, but other planning jobs, Savannah, Georgia, Frankfort, Kentucky, and of course Connecticut. But yeah, most of my experience is either environmental planning, traditional community planning, or economic planning and development.
Can you just briefly describe what some of your typical job duties would be as a land use consultant?
Sure. Reviewing the plans, also reviewing the local comprehensive plans, applications, site plans, documents, zoning, subdivision, and the history of the property. And it's also important to do site visits and look at the neighborhood in person.
Okay, and I believe you testified that you've been a land use consultant here in Rhode Island?
Yes.
Okay. And you and Ed Pimentel work together regularly?
Yes, we do.
Okay. He's a colleague of yours?
Yes.
Okay. Have you testified before any municipal boards or agencies in the past?
Probably about half of the municipalities in the state.
Okay.
Yes.
Have you ever testified in front of this board before?
This board, yes. It's been a few years, but I have.
Okay. Have you ever been qualified as an expert before a board?
Yes.
Mr. Bronk, have you read the report that was submitted by Ed Pimentel in connection with this project?
Yes, I have.
Okay. And is it correct that that report is dated 29 October 2022?
October 2022, yes.
Okay. And are you familiar with the findings and conclusions in that report?
I am.
Okay, so you've read the report thoroughly?
Yes.
Okay. I'm going to ask you to just go through what you can of that report and describe to the board what the findings and conclusions were.
Sure. Just as an introduction, I've gone through the report and I have some bullets, about 3 pages long. I'll move through these as quickly as I can. It's important to me that I capture the highlights in terms of the findings, also the numerical facts. So I'd like to provide those highlights to you. Overall, as you're aware, the report addresses a 70-unit residential development, including 25% affordable housing units. That translates to 18 units. The analysis reviewed comprehensive plan, zoning, subdivision, land development regulations. Also, it used data from the U.S. Census and the 2022 Housing Fact Book. In short, the summary or the report addresses how the apartment development proposal is compatible with its surroundings and location, and also that it would help South Kingstown begin working towards producing much-needed housing, including some affordable units. The proposed building would be behind the existing hotel, which would screen this proposed building from the roadway being Route 1. Additionally, there's a change of grade to the rear of the hotel, this subject property. So there's a topographic slope that slopes downward, which reduces the visibility of the building from the roadway as well. The property is located from a zoning standpoint within the Route 1 Special Management District. Within the report, I'll be making some comments reference to page numbers. Page 5 of the report addresses some comp plan information, and it states from the comp plan, the district is intended to provide, the district being the Route 1 Special Management District, the district is intended to provide for a diversity of compatible land uses and development densities, which may include a mixture of residential, office, retail, light industrial, and the list goes on, so there's more. In addition, it is also the purpose of the Route 1 Special Management District to encourage development of residential uses and to permit residential densities and dwelling unit types that are compatible within a mixed-use environment, but may not be compatible with other residential areas in town. End of the quote. Basically, that's in alignment with the village-centric theme that flows through the entire comp plan, where South Kingstown is intending to concentrate development within these villages. Also, the comprehensive permit is recognized within the comprehensive plan itself as a primary tool for South Kingstown to add affordable units. That is stated within page 2 of the report, extracted directly from the comprehensive plan. Quote, comprehensive permits have been the dominant strategy to develop affordable units in South Kingstown, and the town will continue to pursue this strategy to meet the demand. Such comprehensive permit applications are supported by the town due to the way that they combine smart growth strategies, such as the redevelopment and infill, with the need to provide high percentages of affordable units to specific groups of residents, end quote. Next quote, continue the use of regulatory techniques that support and increase affordable and low to moderate income housing opportunities. This planning report and analysis that's provided, it actually had supplemental spreadsheets. And the 2 main spreadsheets provided dealt with the neighborhood analysis specific to density. And basically what it found is that area, the South County Commons area and along Route 1 is a fairly dense area. It's a high dense area. And that is what has been promoted and encouraged by the town. There are multiple buildings, as evidenced on the neighborhood analysis, and it's a combination of commercial and residential land uses. The other spreadsheet that's provided as a part of the analysis deals with the trend for housing, affordable housing production within South Kingstown. That goes basically from roughly 2005 to close to present day. And what it finds is that there really has not been much affordable housing production over that time. Basically, from over the past 20 years, the town has realized 607 units of affordable housing. That would be 5.57% of your entire housing stock. I believe everyone realizes the state goal is 10%, and that's the goal that was sought by South Kingstown with their affordable housing plan. All that data provided in that spreadsheet came from the 2002 Housing Fact Book. Back in 2004, there were 485 units, which was 5.07% of your housing stock. That's roughly when your affordable housing plan was initially approved. South Kingstown has realized merely 0.5% growth in affordable housing units in about 20 years. That translates to an increase of 122 units over 20 years. That is also 6.1 units per year. In short, that translates to basically no significant progress over that time horizon in terms of affordable housing production, even with the creation of affordable housing plan. So there's a vision, there's a plan, but the implementation is falling short. South Kingstown is not meeting its affordable housing needs as established by its plan and the goals established by the state of Rhode Island. Additional comprehensive plan language, which is found in the report on pages 3 and 4, specifically the housing element, quote, "A wide range of affordable and low to moderate income housing options will exist, developed to maintain residential diversity and to assure that local shops and offices will have a sufficient employment pool. Further, concentrating such homes in our village centers will provide the lower maintenance, walkable housing opportunities desired by many seniors and the young adults alike. More people living in our village centers also means more customers for local shops and services." Regarding zoning, from the analysis and the report, basically, the zoning designations within South Kingstown, the vast majority, almost 74%, are either rural or rural very low density designations. About 19% of the land area is designated as open space, conservation, recreation. So they're protected in perpetuity from basically any development. Specific to multifamily development or multifamily uses, where those allowed, few areas. Zoning designations R10 medium high, RM multi-household, mixed use, commercial neighborhood, commercial downtown, and Route 1 special management district. All of those combined basically total only 4% of the land area within town. So only 4% of the land area in town is even eligible for multifamily housing. In addition, that 4% is not fully available. Much of it also competes with commercial land uses. So the 4% has been in some way developed or aggregated for commercial use. So that's even less land area that the town has to work for in trying to attain a 10% affordable housing goal townwide. Next point, page 8 of the report, another comprehensive plan, quote, focuses on village-centric. Quote, "The integrity of the town's villages will be intact, and the village-centric approach to development which recognizes each village's unique objectives, will be strengthened. Support the control of urban sprawl and dispersion by concentrating population density and infill development within the villages. So, in short, the community has proactively said, we want to prevent urban sprawl. We want all of our development, all of the intensive development to be focused more in our villages. And that's what has occurred with South County Commons. Regarding the existing neighborhood in the area, it's a highly dense mixed-use area. The analysis basically found that there are 12 commercial properties that in total exceed 255,000 square feet. There's also an assisted living, an independent living facility, 2 hotels, 5 residential apartment and condo complexes. So the existing density of this residential and also the intensity of the existing commercial is compatible with the proposed 70-unit residential proposal. It exists today. That density and intensity exists today. That's especially true when comparing bedroom density, since it relates to residents, and the residents relate to any measurable impact that the town would be interested in evaluating. The Route 1 Special Management District zoning already basically limits the number of bedrooms to 2 bedrooms per unit. This development, this proposal, is a combination of 1 and 2 bedrooms. So that's less than what the town would normally allow anyway. So basically, the proposal has 36 one-bedrooms and 34 two-bedrooms. This combination of 1 and 2 bedroom translates to a development, a combination that is not geared towards families. It is geared towards individuals and possibly couples that would live within these units. Regarding the parking, the development proposal offers 104 parking spaces, which matches actually the bedroom count. It's 1 space per each bedroom. Generally, outside of South Kingstown, communities are reducing their parking standard rather than increasing. They're trying to match true demand with the actual proposal. And the reason they do that is for environmental reasons, also to try to reduce stormwater flow, and make the best, most efficient use of the property rather than having excessive parking. So the bedroom count is actually a better measure for trying to relate the parking than the dwelling unit itself. Case in point, if there was a housing unit that had 10 bedrooms, the demand for parking would be quite different than that same dwelling unit that had 1 bedroom. It clearly is driven by bedroom count. Regarding the density, the initial standard for the Route 1 SMD area was basically 10 to 12 units per acre. According to those standards, the initial density would have permitted between 64 and 78 units, or 128 to 156 bedrooms on this property. Again, the initial standards. Those were changed. The current regulations reduce that to 5 units or 10 bedrooms per acre. However, the surrounding use within that area, within that neighborhood, is formed as a result of the initial standards. Those previous commercial uses demonstrated an interest in South Kingstown in maximizing within this village-centric area intensity and density. So this study's neighborhood analysis found that this proposal is consistent with what exists today, including the surrounding existing conditions. The existing residential densities in the area approach 15 units per acre. The proposal is at a density of 11 units, or 16 bedrooms per acre. As a result, this proposal would be compatible with the existing situation in considering both residential and commercial activities. In conclusion, the report, the analysis, the opinion is that this proposed development is consistent with the comprehensive plan and should be supported by the South Kingstown Planning Board. Factors for this opinion include the beneficial manner in which this development is incorporated into the existing fabric of the Route 1 Special Management District neighborhood. Also, a combination of limited viable, high-density land resources for multifamily housing townwide, the presence of requisite infrastructure on site, the neighborhood compatibility in regard to respect to unit density, and also the documented difficulty in achieving regulatory compliance for new multifamily, also affordable units. This project offers benefits to South Kingstown, of which 18 affordable rental units is merely one.
Okay, thank you, Mr. Braun. I'm just going to hit a couple of points that you testified about, just so we are on the same page. I believe it's on page 12 of the report, there's a discussion concerning parking density. Is it your testimony that one parking space per bedroom is a more appropriate parking ratio?
Yes.
Now, the South Kingstown zoning ordinance does not distinguish between the number of bedrooms and units, is that correct?
Right.
Okay. Based upon your professional experience and knowledge, is it your opinion that a ratio of 1.5 spaces per unit is appropriate for this development?
Yes,
Okay. And have you seen that type of ratio in similar developments?
definitely.
Okay. And that's fairly common practice, is that correct?
Right, it's best practice, as I said, standards are being reduced, and 1.5 per unit is definitely sufficient.
You testified that when the Special Management District 1 was created, a density of 10 to 12 units per usable acre was allowed, is that correct?
That's right,
Okay, and that changed or has been reduced over the years?
yes,
Okay, but when originally approved, this parcel could support substantially more density, correct?
right.
Okay. Based upon your professional experience and knowledge, is it your testimony that the proposed density of 17 units per developable acre is appropriate for the site?
Yes,
Just jumping back to the affordable housing statistics that you had mentioned, believe they are on page 17. Isn't it correct that back in 2004, the affordable housing stock in town was around 5.07%?
yes,
Okay, and in 2002, the housing stock was at about 5.39%?
yes,
And as of 2016, per the report that was submitted, that number is only up to about 5.61%, is that
that's
correct?
correct.
Okay, and I believe it was your testimony that the 2022 Housing Fact Book estimates that the affordable housing percentage in South Kingstown is 5.57%.
Right,
So is it your testimony that in about 20 years, the town of South Kingstown has only made about a 0.5 percentage point increase in affordable housing stock?
yes,
Based upon your professional experience and knowledge, has the town of South Kingstown made substantial progress towards meeting its community housing plan?
no,
And is it your testimony, strike that, is the proposed development consistent with local needs for affordable housing?
local what, I'm sorry?
Is this proposed development consistent with the local need for affordable housing?
Yes,
Does the need for affordable housing in town outweigh any effect of the relief that's being requested here?
definitely.
And just one final question, Mr. Braun. You've read thoroughly and understand the findings and conclusions of this report, correct?
I do.
Okay,
yes.
and are you in full agreement with the findings and conclusions set forth in this report?
I am.
Madam Chair, I don't have any additional questions.
Thank you. A couple of questions for Mr. Bronk to get started. Did you review any records associated with development of the initial development of the Village of South County Commons?
The initial plans?
The initial development and when it was created, why it was created, what actions did the town take in order to create the SMD? And did you review anything relative to any land use restrictions in the different districts?
I did not review the original plans for the initial South County Commons development. Well aware of the project even before it was built, but I have not reviewed the specific plans regarding the existing structures, and I have not reviewed any land use restrictions for those properties.
Okay, so you're not aware of any provisions that limit future development specific to particular uses?
No.
Okay. And I realize that the report was written by a different consultant, but you have reviewed it thoroughly. Can you referenced village-like design and development. Can you explain how this particular project fits in with village-like amenities?
Such as the village-centric, is that what you're referring to?
Well, if you read the comprehensive plan relative to village design, it has elements such as a system of safe sidewalks and walking paths and trails, things such as public parks and spaces, public transit, walkable means to goods and services.
So the comprehensive plan specifically addresses individual villages within the community. This is one of them. And it talks about these villages will have mixed-use components. It talks about walkability. It talks about, I believe, shared parking. It talks about a combination of retail, live, work, play. And there are, don't quote me, but I believe there are 4 villages, 3 to 4 within the comp plan that are referenced. And South County Commons is definitely meeting the intent of a village district.
Well, this, I'm making reference to this particular project with regard to things such as public parks and spaces and walkability and all of that.
Could I follow up
Madam
on
Chair?
Sure.
Just quick clarification, if I may.
Yeah.
Jamie Rabbit, Planning Director, South Kingstown. Mr. Bronk, you referenced, don't quote me, but you're testifying to your professional accountability. Did you read the entire comprehensive plan in preparation for this meeting tonight?
I have read the entire comprehensive plan in preparation for numerous projects in South Kingstown.
Have
I
you?
didn't read it specifically for this project, but there are other projects that I'm involved in South Kingstown. I'm fairly well aware of this plan.
When did you last read the town's comprehensive community plan?
3 months ago.
For what project?
Not sure it's relevant to this, but
You said you read it for a project.
I mean, we're dealing with a particular project in this case, right? So the question is whether or not I'm aware of the comp plan.
So
I've
I'll
read it.
rephrase the
I
question.
think
if I'm-
I have read the comp plan.
Did you read the
already
specific
answered.
to your testimony tonight associated with Mr. Pimental's report?
I have not read the plan specific to this project. I have read the plan specific to development in the town, and I'm well aware of it.
When was the plan adopted by the town?
I believe 2 or 3 years ago.
You read the plan, familiar with the plan, but you do not know when the plan was adopted.
I don't think that my knowledge of exactly what year is that relevant. It's a recent adoption.
So I have a couple
Just
more,
wanted
I have a
clarity.
couple
So
of,
just for clarification,
Oh.
he did not read the plan specific to his review in correlation with Mr. Pimental's report this evening.
I'm sorry, his testimony said he was fully aware of the comprehensive plan and is familiar with the comprehensive plan and testified as to his knowledge of the comprehensive plan.
Just,
And you can clarify for the record, Mr. Bronk, if you think it's necessary?
I'm aware of the plan. I stand on that point, and I don't find that those questions are relevant.
But your findings and conclusions are based on your experience and understanding of the Town of South Kingstown Comprehensive Plan, is that correct?
Definitely. I've actually been reviewing and reading the comprehensive plan through its last iterations. So I've used the previous comp plan, and I've used the existing comp plan.
I have a couple of other questions, and then board members, I'm sure, have several comments, and then we obviously want to get to the public as well. In your report, you describe this as infill, so I'm not sure how the definition of infill fits into this particular project, and then you also describe it as redevelopment. Can you elaborate on both of those areas?
Sure. I mean, infill is often described as addressing a development as a part of a whole where there might be a gap. Sometimes that term is used along a main street where there's a vacant lot, and there's a clear and evident need to put a use or a building within that gap. Sometimes it's referred to as a broken tooth. In this case, you basically have a mixed-use development, and the town has already authorized the use of that property for development. It's not designated for open space. It's not designated, it's basically designated for development as a result of your previous approvals and your zoning.
And the redevelopment. Redevelopment is different from infill. Usually redevelopment is when you have a parcel that has a specific building or use, and then that use is changed. But you reference that. It's a little confusing in your report.
I think in light of the previous approval, I may have used the term redevelopment, but clearly there's no building on that parcel today.
Thank you. Paul?
Yeah, given the reference to village centers, if we're going to call South County Commons a village, this isn't part of the village. It's separated by wetlands and Route 1. There has no walkability, no ability to cycle. We've got 70 apartments where the only way in and out is by car. So you said that the beneficial manner that this has been incorporated into the existing, and I'm paraphrasing, South County Commons development, I think is what you said. Can you just explain to me how this is beneficially incorporated into the existing? Because I don't see it being incorporated at all. We did ask about some sort of a walking path connection. I know that there's an issue with the wetlands. It doesn't look like there was any exploration of doing anything along Route 1. There have been no inquiries to DOT about that. So I'd just like to hear about the beneficial manner this has been incorporated, because I'm not seeing it.
Sure, a couple answers on that. I had given some statistics regarding land use and zoning throughout the entire community, throughout South Kingstown. Clearly, those are not villages. Clearly, they're not, they don't exist for mixed use or village centers. There are only certain areas where that can exist. And the South County Commons neighborhood with the abutting properties along Route 1 is one of those areas. So I wouldn't necessarily say that because there is not a sidewalk or a direct connection regarding a pedestrian way, that it's not a part of the overall development, that it's not a part of the overall village. It is. And that is the area that's designated for concentration and intensity and a combination of uses. Let me add to that as well. There's a future land use map, which I did not touch on in the comprehensive plan. And the future land use map it needs to be consistent with your zoning. And the future land use designation for this area, it's a large area. If you look on that future land use map, it's a large area designated for this use, a mixed use type commercial village concept, which is then implemented by your zoning. Your designation of your future land use actually matches your zoning
And I'm not arguing with the mixed-use aspect. It's just the idea that this is somehow integrated and part of a larger village when it is clearly an isolated, and isolated is the word for it, pod of development. It's not part of South County Commons. It may be part of the same ownership, but it's certainly not part of any village that I can imagine to say that this is part of the South County Commons village.
Future land use map actually says otherwise.
Liz?
One of the things that you did not address, at least I did not see it in the report, was the massing and the scale of the proposed building. You did say that it's not visible from Route 1 because it's hidden behind the hotel, but I do have a question. If I could just have you refer to the site views and elevations drawing, which is sheet 6 of 7 that was included in the report.
Page 6.
Sheet 6, drawing 6, which has the concepts. And if I could just have you take a look at concept 2, the inspiration from the Fairfield Inn.
What is it? Page 6 or 7?
You with me?
Oh, and I can direct him. Is this the?
Yes.
Mr. Brock, if you give us a moment, we'll pull that up electronically.
Thank you.
Ms. Carp, is that the elevation you're referring to?
No, there's several smaller drawings and photographs on that sheet. One is called Concept 2,
Okay.
Inspiration from Fairfield Inn. I don't know if you have that as a...
We do, just,
And then Concept number 3, Inspiration from Local Vernacular.
thank you for clarifying.
Okay, there we are. So if you take a look at concept number 2, inspiration from the Fairfield Inn, I think it's pretty clear that it does, from a design standpoint and a massing standpoint, yeah, take its inspiration from the Fairfield Inn. However, if you look at concept 3, inspiration from the local vernacular, and then you look at the small print next to that, it says inspiration on design elements from local vernacular and similar projects. Could you speak a little bit more to that? I know it's not really included in the report, but it seems to me that you do show here that the design elements are used. The entrance has a portico over it. We have pitched roofs that look kind of like dormers. But I have to question the massing and the scale of those elements. There are many ways to put design elements together in a package. And I'm not sure that the way these are packaged in the proposed building really do match the scale and the aesthetics and the massing of our town and the other buildings in our town. And I would ask you to comment on that.
First thing I'm going to say is I can comment about economic development and planning, but I'm not an architect.
Well, I am.
Okay. So I would actually defer to you on design. But having said that, basically, there's a land area that has to be worked with. The development is attempting to get affordable units on the site. The other thing I would comment on, there is not a consistent, not being an architect, there is not a consistent architectural style that flows through the entire South County Commons. And I do remember.
Could I just interrupt you? But there is a flavor, there is a feel, there is a scale. Maybe not a consistent style, maybe that's a good thing.
I think that topic regarding design, massing, has been an ongoing discussion from the beginnings of South County Commons. And I think it continues today.
I have to go back to what Paul said, though. I don't know if we are talking about South County Commons here. Anyway,
Madam Chair, if I just
that's all.
may ask a follow-up question. Again, Jamie Rabbit, Director of Planning. Mr. Bronk, you just testified that you're not an architect. Are you aware that Mr. Pimental is an architect? Is AICP, correct?
I know his AICP. I cannot testify regarding whether he's an architect.
Mr. Landry, do you know if Mr. Pimental is a registered architect? Has any?
I don't know. We'd have to ask him. I think his resume is attached to the report. But in terms of architectural design and standards, we did have our architect testify back in January as to the architectural design and consistency with the design standards.
So just for clarity, Mr. Bronk, you testified this evening that you agree with the conclusions contained in Mr. Pimental's report, which specifically on page 11 deal with scale and massing. So you agree with those as a professional, yet you just testified that you're not an architect and have no expertise in massing or scale. So do you still agree with Mr. Pimental's conclusions?
I agree with Ed Pimental's conclusions. I think massing and scale are different than architectural details.
Are you testifying as an architect or a planner?
I think we've been through this.
Yeah, we made it pretty clear he's testifying as a land use expert, not an architect. But to the extent that he agrees with Mr. Pimental's conclusions, he's testified that he does so.
Jamie, could I just add one thing to what you just said? At one of our previous meetings, I don't recall the dates, there were so many, we did discuss the possibility of maybe another aesthetic option where instead of one long, tall, massive building, that there perhaps might be a way to delineate that building using the vernacular design elements so that it would appear less massive. And we did even discuss the possibility of several buildings, or at least the appearance of several buildings at that time.
Yeah, I can comment on that if I may. So the applicant certainly considered alternative buildings on this property, whether we break it up into 2, 3 buildings. There's obvious construction costs, there's a fiscal impact to doing so, there's a reduction in the available parking on this lot as a result of multiple buildings. There's an existing drainage system that Mr. Prevey had testified about that would be significantly impacted by multiple buildings. So with all the available data and the different project scenarios, this was chosen as the most economically viable and appropriate proposal for the site.
However, I would say there are architectural ways to have a massive building appear as separate buildings just by moving elements around rather than actually having it separate buildings.
Sure, so I guess what I would offer is that this is obviously a very conceptual stage. It's master planned. This is certainly not going to be the final version of what this building is going to look like. We're far away from there if this were to get approved. We have a great architectural team, Hans Strout, and he's taking this in stride and will develop it as appropriate as possible. He's testified as to what the design elements have included, similar concepts in town that he's compared that to. So as this goes on, this will obviously evolve into a more defined project architecturally, but this is a very, very conceptual stage. this is the idea, these are conceptual inspirations, and that design will be more defined as we go through the process. But I do appreciate that there are ways to make it
Up here,
scale down,
right.
landscaping buffer, things of that nature as well.
Thank
And
you.
just to reiterate what Liz had to say, we have had at the forefront an element of design throughout this area. It's one of the few areas within the town that we actually have architectural review. And I think early on, many board members commented on the mass and the scale of the building and how other types of building designs might fit in better. And it, you know, the idea of conceptual master plan is that it's a good point at which to have those conversations before the level of detail of engineering designs has been done at preliminary. And of course, as you well know, the project gets vested once you have a master plan approval. So that can sometimes be limiting. So I think board members feel, and rightly so, that those kind of conversations need to occur at this stage. Go ahead, Joe.
I'd like to ask you a couple questions relative to the parking. Truthfully, I'm a little concerned with reducing the amount of parking.
Do we want to wait on the parking until we have, are you having engineering speak and traffic engineer speak this evening?
Provided testimony relative to the.
Yeah, he provided it, but we will have follow-up, but
Fair
He also
game.
provided testimony that he
Yeah.
believed it was appropriate to base it on the number of bedrooms and not the number of units. So I recently read some articles relative to parking, and I agree with you with the trend nationwide to reduce the amount of parking. So I believe that you're correct in that. In the articles that I read, however, as some of the alternatives, they encouraged on-street parking and municipalities building into their streets the availability of on-street parking. Are you aware if there's any on-street parking in the area?
No. But I would also add, although communities are modifying decade-old parking regulations, there is no one single recipe. There are a number of ways to actually address parking management. I'm familiar.
One of the other ways in the articles I read was the talking of public transportation and the encouragement of using public transportation. Are you aware of any public transportation that currently services that area?
No, I'm not, but I was going to comment.
One of the other ways that they had recommended.
Can I
was-
finish what I was saying? Thanks. I am aware of shared parking arrangements. That is another tool that municipalities use in addressing efficient parking management.
So shared parking, do you have a proposal, or do you know if there's shared parking available for that, for this purpose?
I'm aware that the applicant is discussing shared parking and how the efficient management of the spaces would be used by uses in the area.
But there's no agreement currently in place for shared parking. It's not something we can count on when we make our decision. If we were making our decision tonight, we would not be able to count on shared parking. Is that correct?
I can interject if I may. So the Special Management District encourages and allows shared parking, as we all know, and it actually says that the board can deviate from the parking standards based on the shared parking analysis. You'll hear testimony from our traffic expert that the proposal before you, including all of the uses on the property and the parking that's made available, is adequate for the site.
And then a fourth way that, and that was one of the ways that I had read, was that, it's possible to reduce it. Fourth way was encouraging walking. Pedestrian traffic in lieu of vehicles. Is it your opinion that this is walking distance to village center of either Wakefield? Or do you believe it's within walking distance?
Walkability has different standards.
So how far would it be and how much time would it take?
Excuse me?
If it has different standards, do you have an estimate on how long it would take to walk from here to, let's say, the village center of Wakefield? And how far is that distance?
I actually don't know that exactly. I would relate more closely to South County Commons, and I've heard comments tonight that this is not considered a part of South County Commons, but according to the future land use map, it is. I think that's the closest village that people would go and possibly do some entertainment at the theater, possibly go to dine, possibly go to shop, possibly go to work. I think there's a linkage in that area. So Wakefield, sure. I think that some people would walk it. How long would it take? I'm not exactly sure. What I was going to say is that typically I have seen easy walking distance. People will refer to a half mile. Some people will go further. I'll walk several miles. But the best village, I think, to actually compare it to is right next door.
But you're aware that there's no sidewalks between the two, if somebody did want to walk to that area? Okay. So I do have concern about the parking. Typically, when we have an expert in front of us, we'll accept that expert's opinion unless we have something that we can refute it or have personal knowledge. I will say that I have approximately 50 apartments that I own myself, and I could tell you that 2 parking places per apartment I found is appropriate. Even 1-bedrooms. Matter of fact, I think you had given testimony that this is being geared towards a couple, not towards a family, these apartments. So a 1-bedroom with a couple, I find that the number of cars is closely correlated with the number of adults, more so than the number of bedrooms. So a 5-bedroom house that has a single parent with 4 children will not have as much parking as a 1 or 2, where it has 2 or 3 adults. So I think that you're correct, there's a correlation, but I do believe, from my own experience, that is a pretty loose correlation, and better correlations are with the number of adults that live in the unit. And again, I'm saying that out of my experience. Demographics. Are you, and specifically demographics relative to the need for affordable housing, do you have any thought on what demographics? Is there more of a need for families in South Kingstown, more of a need for elderly, more of a need for young adults? Do you have any idea what that breakdown is?
My response will be more general in nature. Other than the affordable housing plan, I'm not aware that the town has actually done any sort of market demand analysis for housing. I have read many housing market studies in surrounding areas, and surprisingly, it's the demand for multifamily housing is not a single age group. It's easy to believe that it's a younger demographic, maybe a millennial or something like that. That's true. But also, there's equal demand from empty nesters. So you're getting demand often in communities from both a younger demographic, but also an older demographic. The older demographics driven by those who are empty nesters. Actually, divorce rate has a large driving factor. People will say, okay, I'm now single. I don't want the headache of what I've been living in. I want something easier, simpler, smaller. That age group is as strong of a demand as a younger age group.
Do you believe that the number of affordable units being proposed here is a significant amount for the town, given the amount of affordable housing we have now?
I think the number is significant and relative to what has been produced in 20 years. Is it enough? No.
So, from my experience on both the planning board and the affordable housing commissions, it's my belief that we have a need at all demographics. We have a need for young professionals, we have a need for elderly, we have a need for families of all sizes, we have a need for rental affordable housing, and we have a need for ownership affordable housing. What concerns me a little bit is that when we have a project that is pretty significant, it's a pretty significant amount, I think we would be better served with a project that proposes to satisfy several of those demographics versus just one. You had given testimony that you believe that this is not appropriate for families, it's more geared towards couples and elderly.
I don't believe so. I didn't,
Maybe you didn't say it wasn't appropriate, you said it wasn't geared towards families. You said it
That's
wasn't
correct.
geared towards families.
that's more accurate. Thank you.
Well, again, I believe that the community would be better served if we gear it towards, when we have such a significant number, if we try to spread it out and gear it towards several of those demographics versus just perhaps one or two of those demographics. And my concern about this is that we're, as you said, we're gearing it away from families. We're gearing it towards couples and elderly. It seems to me, and if we had proposed this project a little different, maybe with meeting several of those demographics, maybe with not having as many units, maybe with having more recreational space and open space, and gearing this towards what is a critical need in our community for families, and change it around so that instead of having this massive building that's serving 70 couples and elderly, we could better meet the needs of the community. So that's my point. I think, again, the parking, the reduction of parking, this not being within really walkability, and really not necessarily meeting our need. It is meeting an element, right? There's one demographic that's perhaps meeting, but not meeting the rest of that. So those are my concerns.
Mr. Murphy, if I may follow up too, I'll say that there is, this project is not limited to any particular demographic. I mean, anybody that qualifies can live there, and anyone who's income restricted or qualifies for the affordable units can live there. Joe Lombardo submitted a fiscal impact study, and it's part of the record. He's not available to testify, I apologize, but there were some demographics and characteristics about the families expected to be here that's on average with the town. I think it was 2.4 families per unit, or I don't know the exact specifics, but there was a report submitted that may provide some guidance as to what the expected demographic would be here, but I just don't want to say that this is going to be limited to elderly or, to that extent.
Yeah, and I didn't intend to say that you limited it to that. It's geared towards, and there's a difference, obviously, between limiting it and gearing it towards it. In a previous public hearing, I'm not sure if it was you or someone else gave testimony relative to other similar apartment complexes in other areas, Stonington being one of those, and had specifically stated that a lot of recreation area wasn't necessarily needed because in all those other areas, if you look at those examples, there wasn't many children. And truthfully, that kind of hit me kind of hard because I felt that the need in the community is for all those demographics. And to tailor something that's specifically away from a demographic that we need was not necessarily the right approach. So I'd rather see us having the recreational space and gearing it towards it than saying, well, those other towns don't have it, so we're going to gear it away from it. So,
And I wanted just to add to Joe's comment about the parking. Yes, there is a national trend to reduce parking requirements, but those trends tend to be in very urbanized areas where you can walk from point A to point B and you have a healthy mass transit system. So that is not what we're talking about here, and I think his point relative to parking is well said. Other thoughts? Susan?
Hi, I have a couple of questions. So following up something that has just come up, could you tell me what shared parking is and how, if it's not something that we'll see until preliminary, what are your ideas behind how shared parking would work at this project?
I can answer that. So the Special Management District encourages shared parking, and it allows deviations under a traditional application anyway before the zoning board to give deviations to the parking if you can show that the shared parking of this campus is adequate for the proposed uses. We have real data that shows what the hotel is parking at and what has been allocated, and there was testimony, and will be additional testimony with regard to the hotel being overparked, or too much parking is actually allocated to the hotel. It doesn't need as much. We've got correspondence from the management company of the hotel and, you know, what they actually use, and there's been a lot of testimony in that regard. What you will hear from our traffic expert is that you've got an existing use, you've got a proposed use, and parking that's associated with that. The testimony will show and will be that the parking that's provided, particularly on a shared basis, is appropriate for the uses that will exist on the site. Now, we are aware that there is also a third restaurant site that's already approved, and I think it has 50 parking spaces allocated to it. But that project is not before you. It's not being built. If it ever gets built, it will come back before you. And we understand that at the time that use either goes further in the permitting, it will come before you, and there will need to be an additional parking analysis at that time to show that now all three uses are parked sufficiently and the shared basis works. But we've got parking data for the Fairfield. We've got data that supports the parking allocation here, and it shows that there's actually an abundance of parking, some that hasn't even been constructed yet, for the uses that will be on this site.
Madam Chair, I think we have a point of clarification, if we may, and I have my staff who has looked into this, but I'll start. And if I
Brian.
have a question.
Yep.
You just brought up the fact that there is an approved restaurant. I believe it's in your submission material.
Yep.
It's referred to as Restaurant East.
Yes.
It is approved as a restaurant pad, and it requires 50 parking spaces and was approved to have 50 parking spaces. You just stated it's not part of anything associated with this application. Are you relinquishing all your prior approvals associated with the restaurant?
Absolutely not. I don't want to mischaracterize what I've said. That restaurant pad site has an existing approval, preliminary plan approval, and it is part of this plan. I'm not taking away from that. We're not waiving that. It is part of this plan. But if the restaurant use were to go forward, it would need to come back in front of this board for final approvals.
That's incorrect. The restaurant has final plan approval.
Final plan approval. It's a vetted, approved final plan owned by a separate LLC. So if you don't include it in this part of the process, are you eliminating it? Because it requires, by its final approval, 50 parking spaces.
We're at master plan. If this project were to get approved, we know that we would need to amend the preliminary plan at a later stage. This is something council and I have vetted exhaustively. We are aware that we're not waiving anything. We're at master plan. This restaurant use is still part of our plan. We haven't waived it. We haven't tried to distinguish it. It's all part of it. And the parking that we've proposed on the plan considers the shared parking of the entire campus.
Just for clarity, in the submission information you submitted, where's your shared parking analysis for the three uses?
There has been, so we have allocated parking shown on the plans, and there has been testimony and supplemental submissions to show that there is sufficient parking for the uses that are going to be on the site.
I would beg to differ, using a professional terminology, that your engineer in his submittals is parking the hotel at less than required by the regulations, is proposing to park the apartment complex at less than required under the regulations, and makes no provision to accommodate a single parking space to the restaurant. And that is in your packet. So I think it's a point of clarity, and we may agree to disagree this evening, but based on my professional review of the information submitted, you are omitting the restaurant pad from your shared parking analysis.
No,
And that may be an oversight,
Yeah, no, I
but if you add 50 parking spaces for the restaurant, 117 required for the hotel, and the number of spaces, they don't add up to your 241. I believe you're deficient by 66 parking spaces.
So we've asked for a waiver, and the parking that has been allocated.
Are you asking for a waiver for the restaurant's parking? You asked for a waiver, just clarify, you've asked for a waiver of the hotel requirements. That's a separate mixed use not associated with the comp permit.
No, we-
You've asked for a waiver of the apartment complex, right? Because, just bear with me.
Yeah, that's correct.
The hotel requires 117 spaces according to the regulations. Your engineer testified you're proposing 100, I believe 7.
The-
So,
There's currently 136 spaces allocated to the hotel
okay,
with the overflow parking.
you're taking away the overflow parking and allocating it to the apartment complex.
That's all part of our submission. We're not trying to guise that. That's been pretty clear.
So if you allocate your hotel parking and your proposed apartment complex, where's the parking for the restaurant?
We stand by the plans that we submitted in the testimony, the expert reports.
So there, Madam Chair, there is no proposed parking for the restaurant that has final approval granted by the planning board in prior submissions and amendments.
Madam Chair, if I could just clarify for the record. So Mr. Landry acknowledged about the District 5 preliminary plan that's existing. And I'd just like to get the applicant's position about the need to amend the preliminary plan on the record and about what the board can anticipate in granting a decision on the master plan with regard to what's coming, what they anticipate would be coming forward with regard to the preliminary plan. So first, you acknowledge that the preliminary plan will have to be amended, correct?
Yeah, procedurally, we understand that this would be approved conditioned upon that needing to happen.
And so I guess the point that I want to clarify is, even though there may be separate ownership on that parcel of different uses, you acknowledge that the board can consider the whole parcel and all uses on the parcel when granted their condition here, because it's anticipated that the preliminary plan that's existing will be amended as the proposal goes forward. Is that correct?
Yeah, I mean, we've presented this plan, the master plan, with the 3 uses on the site, and we understand that the board can consider that.
Okay, so
as submitted.
I guess I just wanted to clarify that as you can consider the entire preliminary plan site, the site that includes both the 2 proposed hotels, restaurants.
So what's before you now is a master plan for this site to change one of the restaurant pad sites that exists on the site. And so, that's what we've submitted. We're amending the master plan, or excuse me, we're presenting a new master plan for this site because originally the residential use was not allowed, and there was no approved master plan with the residential use, so we knew we had to come back with a new plan to have that use changed, and the three uses are part of this plan.
Okay, so just to clarify with the yes or no, it's the applicant's position that moving forward, if this were to move forward, the board can consider the entire site and all uses on the site as part of...
This, not the entirety of South County, this
No,
property. Yeah, this
the
property.
entirety of District 5.
Yes.
Okay, thank you.
Peter, just to follow up to that, so what happens when a particular plan essentially negates something that has final approval?
Well, I think it would have to be conditioned on making that consistent, and if that means, that could mean amending your prior approvals to make whatever is approved or not approved, but assuming something is approved, if it's inconsistent, then the prior approvals would have to change. And I don't know, do you agree with that as well?
Yeah, I mean, we talked about this amongst ourselves. It's a unique situation. I mean, you had a 1998 master plan approval for the entirety of South County Commons. There was a restriction on the residential use for the site, and when the Fairfield Inn came in, we didn't need to go back to master plan, even though there were no uses, there was no hotel on the 98 master plan. There were no uses defined. We came straight to preliminary, and that was the whole business with coming and showing that we were vested in the 98 master plan, went straight for preliminary. We understand that there was some restriction on residential uses for District 5. That's why we're here. That's why we presented a new master plan. We could not amend the preliminary plan and not come back to master because there was no approved residential use for this at the master plan stage, if that makes sense. We're coming all from the 98 master plan, and the hotel was allowed to continue because the uses conformed to that original master plan, even though no specific uses. There was no plan that said, this is going to be the Fairfield and these are going to be restaurants. It had a list of uses that were intended uses, I think is the word that it uses for District 5. So we went straight to preliminary with the Fairfield Inn, and Eric had testified at length about that. But we knew we couldn't just amend a preliminary plan without releasing this restriction. That's why we came to you with the new master plan. It's not common, I understand, but that's the procedural.
So thank you for answering my question about shared parking, but I'm sorry that still don't understand how that works. I think my concept of shared parking is that you have daytime uses and nighttime uses, and they sort of meld together where the office park folks go home and the residences come. But you have two very consistent uses here where a traffic study at 3 o'clock in the morning is going to show there is no daytime use. You've got all your folks home at 3 in the morning. And on a hot July night, when you've got a full 100-unit hotel, and then you've got your apartment complex and maybe a couple parties thrown in, there is no sharing because you have no daytime use, which sort of goes back to your comment about this being a village with mixed uses. There seems to be one use. There's no retail, there's no place to buy a pack of smokes, there's no place to get a drink, there's no mixed use here. You've got a hotel and you've got a residence and no other use. So how does the shared parking work if it's a consistent use of all the property? So that's what I'd like to understand about the shared use.
Yeah, I mean, my understanding is that if you can show, so it's mixed use because you've got commercial and residential. Right now, you've got a hotel, commercial use, and 2 restaurant sites that are approved for the property.
So you're you're considering the hotel to be commercial?
Yeah, well, it's mixed, it's a hotel and a residential property that is going to be, is proposed for this property. So it's mixed use in that sense. The shared parking analysis, so the shared parking analysis is whether or not the existing uses on the site you can allocate the parking that's available to those respective uses, and you can park it. And there's data, and we have testimony in the record to support that the parking that is going to be made available for the uses on the site are sufficient to support both the uses, and there's data to support it.
But the parking will be simultaneous with all your uses because it's all folks sleeping there. So you can't share the parking if you've got all the same, unless I just misunderstand what sharing parking means.
Shared parking is shared parking, and I leave it to the experts. I'm not a traffic or parking expert, but the data and the testimony supports that the parking available for the uses that are on the site and are being proposed is sufficient to support the uses.
But you've also, I think, unless my notes are wrong, you've explained that we won't understand your shared use plan until after you're vested with master plan. We'll find out later how the shared use is going to work out for parking.
But we are required to show that the parking is, we've asked for a waiver from the parking for the residential use, and the data supports that 1.5 spaces per dwelling unit is appropriate for what we've proposed. The ordinance requires two spaces per dwelling unit. And the testimony in the report supports that the 1.5 spaces per unit is sufficient
Madam
to
Chair,
satisfy the waiver.
I don't want to interrupt, but I'm going to ask to interrupt.
Go ahead, Jamie.
We just spent maybe 5 or 10 minutes listening to an attorney testify on traffic and parking and shared parking, and a planner who says he hasn't reviewed the parking and he's expertise in housing and economic development, but not site development or parking. Mr. Bronk did testify that he's aware of instances where this type of parking works, but did not specifically reference a report, an ITE manual, a planning study, or a specific project. I'm aware, I believe that Mr. Landry does have a consulting team here that may be more appropriate to respond to the questions associated with traffic, parking, and shared things. I do want to say that based on my review of the information submitted, there is no discussion about shared parking as part of this application process between a restaurant, a hotel, and an apartment complex. Mr. Prevey, in his statement and his conclusion to his parking analysis, defers that to preliminary. He does not opine on that today. He kicks that to the next permitting process. I'm not here to say that whether that's correct or incorrect, but to continue to hear the discussion that we're contemplating shared parking, that these mixed uses work together, is not in the record and has only been put on the record tonight by their attorney. And I absolutely understand and appreciate Mr. Landry trying to answer the questions based on his knowledge of the information submitted. But I think you're looking for the experts to opine on those questions. And they're in the room, so I believe they are.
Yes, they are, and I agree with you, Mr. Wright. I think the engineering professionals, the traffic professionals are more appropriate for those.
Susan, did you have additional questions?
Yes, very quickly, though. And I know this, we'll probably talk about this later. Can I just understand that if we approve this project, then next week, the hotel could break ground on a new restaurant without needing to come before us because it's already pre-approved? So they will not come back before us, and they can develop their restaurant on that front pad by right, based on the approvals we've already given, and that this wouldn't,
So I could
I just want to understand.
So I could answer that question. You could, if you just were to approve it without addressing that issue, then yes, you'd be right. They have final plan approval. The approval would not be necessarily inconsistent, so it is possible. What I'd suggest is that if you do approve it, it's best that you would address the issue one way or the other. And it could be that you approve it and say, there's simply not enough parking on this site with all three uses, and therefore we're approving it on the condition that the restaurant pad doesn't go forward. At which point, they could choose to either abandon this approval or abandon the final plan on the restaurant.
Sorry, so the separate ownership, separate lot, we can cross the boundaries on that?
So that's kind of why I was asking that question of Mr. Landry earlier about, acknowledging that it requires that amendment at the preliminary plan stage, and that it's the applicant's position that you can consider amendments to that existing preliminary plan as you go forward, because those issues could come up. It could come up, just to use a different example, that you want to have screening from Route 1 with a berm or something along those lines. Well, it may mean that you need to not only amend the preliminary plan, but you need a different LLC to be involved. But it's the applicant's position that they are willing to accept that condition, that a preliminary plan amendment will go forward, even though they may need to get other LLCs involved.
Madam Chair, if I can just expand upon that, and again, we've been here many nights, sometimes just with counsel. I believe Mr. Landry may have testified early on that the applicant, as an LLC, is also in control of the hotel parcel, as well as in control of the restaurant parcel.
So there are two separate LLCs that have been made applicants to this project. There's Southern Rhode Island Hospitality and Suffolk Realty. So the parcels that are subject to this application are owned by two separate entities, but are both applicants, if that helps.
So I'll expand upon that. If the planning board at some point in time in the future asked, or in a condition required additional buffering on the front parcel, the applicant is in, for this subject matter, being an apartment complex, is in control of the restaurant parcel, so that that condition could be met because the apartment developer is the same as the Restaurant East developer?
I'd have to ask, I can't recall if there's a separate LLC, but I think I think the existing restaurant site that is subject to this application is Suffolk Realty. And the hotel is owned by Southern Rhode Island Hospitality LLC, which includes that restaurant pad site.
Okay. So I know at some point it will come up that, you know, under law, there's 3 separate entities, and it wasn't clear with me that all 3 are part of this application. I think we're receiving testimony tonight that Mr. Landry at least is saying that all 3 parcels, Restaurant East, existing hotel, and the former Restaurant West, are all subject to your regulatory authority as under this permitting process, and that he's looking for clarity whether his applicant, through the different LLCs, can opine on a condition on land owned by someone else.
Well, I would just say that the application as submitted includes lots 50-4 lot 26 and 50-4 lot 22. That's all that's part of this submission, and that's all that's before the board, and I'll just leave it at that.
So then the restaurant pad is not in front of this board.
If it's on a different parcel.
Then it's not in front of this board,
Do
because
you
it's
know
on
whether
a separate parcel.
To mix and match parking or anything like that?
So I guess I'll just ask the pointed question, since we're talking about shared parking, and it's going to involve shared parking between 3 uses. Is it the applicant's position, as I just explained to Ms. Axelrod, did you disagree with that when I said that they could approve it on the condition that the existing restaurant pad could be eliminated?
No, absolutely not. No, we're not.
And I don't
conceding.
mean the back restaurant pad, I mean the front restaurant pad.
Oh, no, so if this doesn't go forward, I mean, we're not waiving anything. We've got an approved plan for the restaurant, the hotel, and the other restaurant site. All that is before this board is a change in use from that west restaurant site to residential. That's it. That's all
So
that's
I guess,
before the board.
just to make the question as clear as possible, front restaurant site, could this board approve your back residential on the condition that neither restaurant site would be developed? At which point?
No, we're not, no, absolutely not. We're not waiving that. This is just a master plan submission on the west restaurant site, residential for and associated parking.
Is it your position that the board has no authority to consider that front restaurant site because of the separate LLC?
Well, it's not part of this application at this time, and I think there's just maybe a mischaracterizing it. I mean, we understand that there's an existing approval in place for the entirety of these uses, and that at some stage, we'll need to amend the existing preliminary plan approval for all 3 uses. We understand that's going to need to be amended, but we need a master plan approval in place before we can do that, and the master plan that we've submitted to you involves this residential use. It involves the hotel parcel because there's a lot line that runs through where some of this development is proposed to take place, and there'll be an administrative lot line change at a later date. So, and some of the drainage systems are being moved, and we need both applicants and both lots as part of this application. So all that's before, we're not waiving anything. We're not saying this board has authority to eliminate that 3rd restaurant use. Absolutely not. I mean, there's already a valid approval
So I
pending.
guess, let me just jump in. If we realize that it's going to have to be conditioned on amending that preliminary plan, my position would be, and I guess I'll ask your position, wouldn't it open up that entire preliminary plan to be amended?
Not until we're at that preliminary plan stage. I think the problem is we can't amend that preliminary plan and we can't discuss it until there's a master plan in place that
So
deals
I guess
with the residential.
That sounds like it's putting the,
yeah.
yeah.
Just for clarity, and again, planning and process, right? That's what we've been grilled in as planners that, follow the administrative process. So I don't understand how Mr. Landry can say you can't amend a previously approved master plan that includes 3 uses, that you only can consider amending a master plan for 2 of the 3 uses. So, and again, I'll go back to, you're saying now that the restaurant pad is not part of this application, It's not referenced in lot and block number, yet the supporting information associated with traffic and parking eliminates the parking for the restaurant that you say is not part of this application. So how can you eliminate the parking for it
So,
as part of this process?
again, we've gone through this exhaustively, council and I. The 1998 master plan did not have defined uses for District 5. There was no hotel, there were no 2 restaurant sites, there was no defined use on that plan. Normally, in today's standards, you would come in with a master plan with those defined uses, which is what we're doing now. The 98 master plan didn't define those uses on the plan. It had intended uses or perceived uses for the site. And one of them said no residential uses, and we acknowledge that. We went straight to preliminary plan, even though there was no master plan with the hotel existing on it. We went through a hearing before this board to show that we were vested in the 98 master plan. There's a decision in correspondence with, I think, Attorney Kenyon at the time in that regard. That was in 2017. And then the Fairfield project went through straight to preliminary without ever going back to master plan. So we're here before you to amend the 98 master plan because there was some purported restriction on residential uses. If that wasn't there, we would have gone straight to preliminary. We never would have come back for master plan.
But you're here tonight to amend the previously approved master plan.
We're here, that's correct, the 98 master plan, we came in with a new master plan that releases that residential restriction
So you're here to amend the master plan for District 5.
for these, as with respect to these parcels, the parcels that are subject to the application.
I guess I have to jump in just for a minute because the 1998 master plan, so if we're here to amend the 98 master plan, that didn't have any details as far as unit count. So if you were amending that, you could just amend it by saying the restriction on no residential is eliminated, and then you would come to preliminary plan stage and have your unit count, at which point I think you'd agree you'd have to amend the District 5 preliminary plan, which is in place, which in my opinion would open up the District 5 preliminary plan entirely because you're asking for it to be amended. I guess if your position is you're here to ask for an amendment to the 98 master plan, is all you're asking that the restriction be eliminated and that the rest of the details could be hashed out at the next stage of review? Or are you asking to get vested for a particular unit count?
No, not, so the master plan that's before you has 70 units proposed, affordable housing, another component we all know. The 98 master plan did not have unit counts, my recollection. It had uses that were allowed and uses that were not allowed, and there was a residential restriction. We are here to ask for a new master plan as to residential on these 2 parcels. And if that residential restriction was not on there, we would have gone straight to preliminary. There was a restriction on that use for these parcels, so that's what we're asking to modify.
So if the original master plan approval allowed residential use, then all of your unit count issues would have been addressed at preliminary. I think the problem that we're running into here is that you have an old process that was started that's now 90% constructed in terms of the Village of South County Commons, and you're coming in with a new master plan that is not compatible with the process that was already started. So I think what Attorney Squires is trying to say is we need to, the easiest thing to do would be to keep the same process going.
Brian, Mike?
It is on, I'm sorry. Amend the original 1998 master plan to allow residential use, even to allow an affordable housing development, and then come back in at preliminary, just as the rest of the Village of South County Commons was done, and do your detail work there for all of District 5.
Well, I guess I'm thinking that is what we're doing. We're amending we're amending the master plan to allow the residential uses for these properties in the density that we've proposed.
That's not what you've been calling it, though. You've been calling it a new master plan versus an amendment of an old plan, and I think it's going to be pretty important.
No, I mean, I sent the letter saying we're requesting an amendment to the 98 master plan with respect to these lots. I mean, it's not the first time that's been done in South County Commons.
Are you referring to the May 5th letter?
The May 5th and that, which letter is that?
I think he sent a letter on May 5th asking that the 98 master plan be amended, and it was something along the lines of,
Yeah. So when, May 9th, you submitted a letter to Jay Parker, Principal Planner. Please accept this letter confirming the extension to June 1st. And the request include a proposed amendment to the 1998 South County Commons Master Plan to allow residential uses on the lots subject to this application.
Yeah, that's exactly what our request was.
Okay, so you're acting like this was here forever, that the
We've
amendment to
never-
the master plan, no, it was brought up at the TRC over 6 months ago.
No, we've never been quiet about our intention to put a residential use on this property, and that this is a new master plan. If you want to change a use on a piece of property that already has an approved use, you come in with the new master plan and amended plan, and that's what we've done.
So I think that it would be important for the board to have some kind of legal memo with regard to the consequences of approving a new master plan before amending the preliminary plan and what the, legal and practical ramifications of that might be. And from a practical perspective, it's now almost 9 o'clock. We only have until June 1st, via the applicant, which is next Thursday. We have a room full of people who have been patiently waiting to speak. We'd like to proceed in a fair and equitable way, but, this is becoming sort of a circular conversation. And, I would
No,
like any recommendations
no,
that we can
Madam
have.
Chair, I think you're appropriate in your comments, and to Mr. Landry's point earlier, I believe you have 2 additional professionals in Beta Group, as well as Dupree, to talk about parking and traffic.
Eric has already testified. I'm not sure we need to go back through that whole testimony, but certainly Paul Banyan of Beta Group for traffic perspective.
Why don't we have him speak next?
Good evening, Mr. Bannon. Can you just please state your name for the record?
For the record, my name is Paul Bannon.
Can you please tell the board your current occupation and place of employment?
I'm a traffic engineer with Beta Engineering in Lincoln, Rhode Island.
All right, and how long have you been in that position?
I've been at Beta for over 20 years and practicing transportation engineering for almost 40 now.
Could you just briefly describe your educational background for the board?
I have graduated from the University of Rhode Island in 1982, civil and environmental engineering degree. I've been working in the transportation engineering industry for local engineering firms specializing in traffic and transportation engineering.
Can you just generally describe to the board the types of projects your firm gets involved in, or you personally?
Over the years, I've done numerous Rhode Island Department of Transportation projects, highway improvement projects, traffic signalization, arterial projects. Was a consultant for the State Traffic Commission for over 6 years doing traffic and operational studies for the State Traffic Commission and recommending mitigation and/or improvements at the request of local communities. And I've done hundreds of traffic impact studies for residential, commercial, multiple mixed-use projects.
Okay. And have you testified before municipal boards in the past?
I've testified in over 39 communities in Rhode Island, excuse me, in Rhode Island and Massachusetts, and in Superior Court in Rhode Island, Massachusetts, as a traffic expert.
Have you testified in front of this board in the past?
For decades, yes.
Have you been routinely recognized as an expert in your field?
Yes.
Mr. Bannon, did you prepare a traffic study for this property back in 2017, 2018?
Yes, as part of the development plan review process, we completed a traffic impact study for the District 5 component.
Okay, and that included the Fairfield Inn and associated restaurant sites?
Yes, it was evolved at the time. It was the hotel, potential office uses and/or restaurants. And the final approved project was the hotel with the restaurant pads.
Okay. Did you consider the traffic impacts along Hampton Way?
Yes.
Okay. And traffic impacts on or from Route 1?
Yes, we did.
Okay. Did your 2018 report conclude that there were no significant impacts as of that development, for that development?
Yes, I've been working on this section of road, including South County Commons, back in the late 1990s, working on designing the roadway improvements for access to those. Did this jug handle twice and coordinated at the time with Wakefield Meadows to redesign that jug handle to accommodate development of that property and this property.
Okay, and were you asked to reevaluate and reassess this proposed project?
Yes, as part of this most recent application, we were asked to determine the effects of changing that use to the residential use, and we submitted a supplemental letter back in January.
Okay, and that supplemental letter or report is dated January 23rd, 2023?
Correct.
Okay, and that report, again, analyzed the impacts of this proposed residential use?
Yes, it shows, or it demonstrates that the previous approved use was a more intensive use in reference to traffic generation than the apartments, and that it'll be a lesser impact than what was originally approved.
Okay, so it's your testimony that you took your original 2018 report and updated it for this proposed project?
Yes, we looked at the trip generation numbers and the operational conditions of that future condition.
And that includes impacts to Hampton Way and Fairfield Drive?
In the signalized intersection with Route 1, yes.
Okay. Mr. Bannon, are you familiar with the report submitted by Dupree Engineering on December 7th, 2022?
Yes.
Okay. And that letter was from Mr. Prevey to Mr. Abbott, the planning director?
Yes.
Are you familiar with the letter? Have you read it?
Yes.
Okay. This letter discusses the demand for both the hotel and the residential use. Is that correct?
Yes, it was an analysis of the parking conditions on the site and the requested relief from the zoning.
Okay. And do you agree with the conclusions set forth in that letter?
Yes, I've done numerous parking studies for apartment projects and have found that the 1.5 rate per unit is a typical rate. It's an accepted rate in a number of communities in the South County area: North Kingston, Charleston, Richmond, East Greenwich, Westerly, Jamestown.
Okay. Is it your testimony that that proposed ratio is sufficient for this use?
Yes.
Okay. You were in the room when there was some other testimony given here tonight, correct?
Yes.
Are you familiar with this one space per bedroom analysis?
Yes, that the 1.5 and the 1 equate, that you would try to equate that to come up with an acceptable condition that would be sufficient for the proposal.
Okay, and Mr. Bannon, is it your testimony that based on your 2018 traffic report as updated for this project, there'll be no significant impact to traffic?
No, the conclusions of the original study remain valid, that adequate and safe access can be provided to this project as the roadway system was designed to accommodate this project and the adjacent.
And that's this residential use that's proposed, correct?
Correct.
Okay. And you updated your data to reflect that?
Yes, based on earlier testimony and discussions with the town, we understand there were concerns relative to the study that was done in 2017 and the time lapse between now and then. So we obtained additional count data from the DOT and their record count station just up the road, and we also did a updated count this past May for it.
Okay, strict that, is it your testimony there'll actually be a reduction in traffic with this use versus what's already approved for the site?
Yes.
So there'll be a reduction in traffic counts for a residential use versus the commercial use?
Versus the size of the restaurant that was proposed, and the updated data that we obtained was consistent with the 2015 data that was used in the initial study.
Okay. Did your study conclude there'll be fewer peak hour and daily trips?
Yes.
Are there any significant impacts to traffic on Route 1 or Hampton Way? Will there be?
No, as testified to, that the intersection was designed to accommodate this demand.
Based upon your professional experience and personal knowledge, are there any adverse impacts to traffic as a result of this proposed development?
No, this proposed use is a reduction in traffic during the peak periods from the originally approved. That shows that the intersection operates in an efficient manner, level of service C, or better during the daily peaks.
In part of your analysis, do you consider pedestrian safety and things of that nature?
Yes.
Will there be any adverse impacts to pedestrian safety or resident safety on the site?
No, we'll work as we go through the design process on a pedestrian and other accommodations typical of residential demands or needs. I noted that the question came up on public transportation. Yes, there is a RIPTA bus route that runs through here and into Wakefield Assault Pond Plaza, up into Providence, stops at Wickford Junction. Typically, we can work with RIPTA on certain projects, propose stops and or other accommodations to support and or promote public transportation. And our public transportation projects these days we call traffic demand management. We work with tenants and to try to find methods to reduce traffic demands from that property, whether it's public transportation or other modes of transportation, bicycles, that we provide those services, sidewalks to get to places. So that's typically part of the process as we go through final design.
Okay. Your testimony here this evening is consistent with your report dated January 23rd?
Yes, it is.
Okay, and I won't ask you to get into all the specific scientific data, but that's found in your report, is that correct?
That's correct.
Okay, and that's consistent with your testimony here this evening?
Yes, it is.
Okay. Madam Chair, I don't have any additional questions.
Yeah, I have just a couple of quick ones. Math question. You said that 1 and 1.5 parking spaces equate, meaning they're the same. So 70 is the same as 105? I don't understand that.
No, per bedroom, 1, per unit, 1.5.
But again, not per adult. You're talking about per bedroom.
Per unit of apartments or bedrooms.
What was the original capacity analysis as far as parking spaces for the restaurant?
I didn't look at parking for the restaurant as part of my
Okay, then how
purview.
could you tell that there would be a reduction in traffic for the restaurant versus the apartment complex? Because it's still a question of capacity.
It's based on ITE trip generation, looking at trip volumes, at how many units would generate X amount of trips in the peak hours, meaning vehicles entering and exiting the site, not parked on the property. That's a separate analysis.
And then you mentioned RIPTA, and you talked about working with RIPTA to promote. I mean, that's kind of vague, and to try to reduce traffic demands, yet earlier you said that there wasn't going to be a problem with traffic, and then you also referenced sidewalks. And given the current financial status and capacity of RIPTA, I'm just wondering how that would all work.
There's two different
All connected.
issues. You know, when we do development projects, the trend in the industry planning is to promote non-vehicular means of travel. So you're not, every trip that you leave or have to go somewhere, whether it's Wakefield or the beach, you use your car. So it's providing opportunities and teaching and working with your tenants to show them or provide them opportunities. This is practice that we use.
Yeah, I understand it's all theoretical, but how would you do that when you don't have sidewalks and you don't have connections from point A to point B? How you can promote alternative?
In that,
You're not going to walk
again,
along a limited access
we're in the
highway.
conceptual stage of review.
Got to be realistic.
And these are issues and items as part of the process. If the town says we want sidewalks here as part of the next phase, that's something that we would have to do or consider.
Sounds very theoretical. Susan?
That's not theoretical, that's practice.
Hi. So my questions are following Maria's. So you had just said something about proposing RIPTA to have a bus route on Route. There is no public transportation on Route 1 right now.
Yes, there is. It's Bus Route 65.
Madam Chair, can I clarify that?
Go ahead, Jamie.
And it was just alluded to by Mr. Bannon. RIPTA does have a bus route. It is 3 trips in the morning. It is a park and ride run. So it starts in Narragansett. It stops at Wakefield Meadows. Its next stop in South Kingstown is at Route 1 and 138 at a commuter lot. 3 a.m. trips, 1-hour headways, and headway means an hour between buses. And it has 3 p.m. return trips from Providence, first stopping at stops prior to South Kingstown. But in South Kingstown, Route 1, 138, Wakefield Mall, and then Narragansett. Route 1 is a limited access highway. There are no sidewalks on Route 1. And this is a commuter run. This does not have any interconnection or relationships to daily service within the community. This has no physical connection to what everyone's referring to as a village, which is not this parcel, but located to the north in South County Commons Village. The developer has already testified through Eric Prevey that they cannot connect this development with South County Commons. And if there's a different statement, I could be corrected this evening. But there is transit here. It's commuter-based. It's not your average urbanized internal connection to shops and services. Is a commuter service.
And Jamie, the morning trips, you said Narragansett, you meant Wakefield Mall, not Wakefield Meadows.
Sorry,
right?
Wakefield Malls. So I believe the first run is 6 a.m., 7, and 8.
Okay.
And then it returns like 3, 4, 5.
It's
p.m.
the
from
commuter
Providence.
route and times.
So it goes from Wakefield Mall to the tower without a stop in between?
It starts at Salt Pond Plaza.
Yep, and then it goes
And
to the
Narragansett.
Wakefield Mall,
Yep.
and then it goes up to the tower.
Correct.
So that if you were living anywhere in between, that's not an accessible transportation mode.
Wakefield
You have to
Mall
get
is,
to the Wakefield, but you can't get to the Wakefield Mall from this project.
yes, you can.
In a non-car-centric way, as you had
Yes.
proposed, how
Yeah.
would you get to the Wakefield Mall?
There are bicycles, and it's not that far from... No. There's connections.
I think the connection between the Wakefield Mall and this new project is through the neighborhood that belongs to these folks. There's otherwise not a safe way, unless you're riding on the shoulder of Route 1, to get between one and the other. And that's, I think, a concern for at least for me on the board, that there is no way to get to any location from this project aside from the shoulder of Route 1 or through private property. And then you can't get to the bus because the bus is at the Wakefield Mall. So I guess I'd like some expansion on how we could.
We'd have to look further into providing that access.
At what part of this of our approval and our process would we be looking at those alternate less car-centric modes of transportation.
This is a conceptual idea, and you get into the details as you go through the process. We all know that. We don't know what the drainage design is going to look like. It's a concept. So that's what we do. We have ideas, we have thoughts and direction, and then we have to act on that. That's part of the process.
But if you can't put together your proper drainage model, then the jig is up. If you can't find alternate transportation for the people, that's not a stumbling block, it just makes it more difficult. You know?
It's part of the process that we try to provide that, if we can. It's a goal in the planning process to try to reduce travel demands on our roadways.
There's also a difference between try and require. For example, if your drainage plan isn't up to snuff, then you need to fix it at preliminary. I don't know how you're going to be able to correct something that you have no control over.
We don't have a traffic issue with this project. And that's where I'm saying, these are goals and ideas that you try to, just for the sake of, that's proper planning process and that you go through. We don't have to reduce the demand created by this project relative to traffic. The intersections that service and the roadway that it services are adequate and provide safe access to the property. And that's our burden.
Go ahead, Joe.
So I appreciate your testimony, and trying to stay open-minded.
Joe, can you just pull the mic
I appreciate your
forward? Thank you.
testimony, and I'm trying to stay open-minded as possible. I do find it conflicting, however, when you have one expert that says that these are tailored towards elderly, and then the second expert saying the transportation can be by bicycle. So you could just see where we have some conflict here. And I also, a lot of this reduction in parking seems that to work out, we need to work out the shared parking, we need to work out perhaps transportation. Those things are all possible. None of those things are guaranteed. I also, in other projects, I've seen that worked out at the preliminary stage instead of the master stage, which is what you actually said. But typically, those lots would allow for additional parking if we, at that time, determined that it was necessary or we weren't able to come through with those shared. In this particular case, I'm not sure that that lot is going to allow for that additional parking if that transportation doesn't come through or if that shared parking. I would think a better approach would be that at this stage, we plan on 2 parking places per unit, with the understanding that at the preliminary stage, which will be the next stage, after you've had opportunity to work with Rhode Island DOT, after you have a chance to work with the other property owners relative to shared parking, at that point, you could provide a proposal to reduce to 1.5. You'd be able to give us all that, what those agreements are, what the bus routes would be. So I think we're putting the cart in front of the horse. I'd rather put the horse in front of the cart. Let's, at this stage, go with 2, and if this goes forward, I don't know if this is going to go forward or not, but if it went forward, and then we could consider reducing it once you've worked out those details with those other stakeholders. So that would be my proposal.
And I don't want to go back into that circle of the other parcel, but I think that is the avenue of approvals, that it's the burden of the applicant to prove that that final element fits and has the sufficient parking to accommodate it. If it's not, a restaurant can't work there. If it's a bank or whatever, it's the burden on that last element, because you're talking about an unknown.
Repeat the question. Well, we're asking for the waiver now, it would be vested in the waiver request at this.
There's the circle.
I mean,
You asking for, well, let's get what we know would serve now, and after we get these other things agreed upon, then we'll ask for a reduction. You're saying, well, let's get the reduction and we'll try to figure it out later.
I mean, Mr. Bannon has testified that the traffic is sufficient for the property, and I think the question is whether or not there's alternative public transportation.
It was not just the traffic, it was also
That's
the
just an
parking.
amenity.
Yeah, I mean, we're not required to provide that as part of the development process. It's something we've certainly considered. We've considered walking paths and connections to South County. We've considered all those things. And there's testimony to the effect of why they're not practical or we're unable to do so.
Maria?
Yes.
So just a quick question about that. I know that, the idea of a path through the school and through the wetlands to South County Commons sounds like it's not going to work out for a lot of reasons. But I'd also asked about exploring with DOT the possibility of doing something along the right-of-way, right along the road, which actually, I think,
It's a scenic highway, so it's a town matter that what they want to see relative to their main corridor and this historical.
well, I guess what I'm asking, because it hasn't happened yet, is that it at least be explored. That there be a conversation with DOT. If DOT says absolutely no way can you do this, then we have an answer. But just to at least explore that possibility of making a connection along the road frontage. There is a minimal wetland that would have to be crossed, but most of it is outside a wetland area. I think it could be kept far enough away from the road shoulder that it could be safe, it could be attractive, and it would connect those two places. That would solve a lot of problems, I think, with this development. And all I'm asking is that you look into it and come back and say, here's the text of the conversation with DOT in which they said, sure, maybe, or no, absolutely not, or, but something.
I haven't been part of that process when they were talking about the connection, so I'll talk to our team, see what they did consider and possibly provide options.
So, Madam Chair, Jamie Rabbit, Planner, just for clarity, understanding that Mr. Banning, in essence, is testifying with regards to level of service and intersection safety. We kind of deviated a little bit from what you intended to testify on.
Well,
tonight.
that's part of what I review and approve through the DOT anyway.
From my perspective, listening to the testimony, as a planner, and just with my background, 20 years with an MPO, 20 years assigned to a transit district, as well as multiple towns, and then another, too many years, but 12 plus, so 34 plus years of planning experience. In reviewing Beta's report, find no fault with the determinations on intersection safety or with regards to level of service. There is a potential impact on convenience, because there is no development there now, and there will be proposed development at some time in the future, whether it's a apartment complex or 2 restaurants. That will affect that intersection because it is not built out yet. Again, as a planner, reading that report, the impacts on safety and level of service are acceptable. Where I think the conversation starts to lose credibility when you start to talk about eliminating parking and trips with unrealistic aspirations that you're going to build a sidewalk on a limited access highway, which is a scenic highway, that you're going to encourage either elderly or young children to bike along Route 1, which is a limited access highway, where the only way to get to the shopping center at close to a mile away, with the center of Wakefield Village, because this is not a village, that's my professional opinion. It's 2 buildings being proposed right now, a hotel and an apartment complex, and that does not constitute a village in any way, shape, form, in any planning document I've ever reviewed. There is no interrelationship to other developments within the community without connectivity, without vehicular access. But I think you're asking a lot of Mr. Banning, I'm actually defending him, with regards to his potential expertise and what he's charged with regards to development. I think he did a best attempt of what a traffic engineer or transportation engineer would say. Yes, in any development, we will explore reducing trips by looking at alternatives, bike, transit, walkability. However, to Mr. Jordan's point, the likelihood of biking, walkability, or transit at this site is suspect. It will potentially be explored at a later date, but working with departments of transportation for close to 30 years, I can reach my own conclusions.
Do board members have any other specific questions for Mr. Bannon at this point? Because it's now 20 past 9, so we've had 2 hours of testimony and granted interesting and engaging conversation. However, the folks that are here in the audience want to be able to speak and address their concerns, and we do usually take a 5-minute break at 9 o'clock, so if we could just have that 5-minute break, if everyone is in agreement, we'll be right back.
Thank you.
Thank you.
You put a tie on tonight. I mean, wow.
They made me push back last week.
I want to see the jacket too. I mean, let's. Dress for the job you want, not the job you have. Dress for the job that you want, not the job you have.
Is it really rude of me to say that?
but I mean, actually, somewhere in the report, it mentions that there is a bus stop across the street in front of the government center, which I'm trying to picture. There might even be like a little shelter around the side. The bus maybe takes that exit for the government center and then just turns right back out again. But I thought, so people from here are going to cross 4 lanes of Route 1 to get there? I did take one myself. Got home from work and laid down for an hour. Hey Jeff, how are you? Good to see you. What brings you out tonight? Do you live in the neighborhood or do you? Those homes are beautiful. My friends Randy and Peg Collins live in the first unit as you're driving on the right. And I remember the first time I walked in and, wow, this place is really nice. They did a really good job. I know, they're beautiful inside. And they've got, out back, they've got a deck looking out over the woods. And it's pretty.
No one's leaving now.
Chairman of the city. Protect Rick lives in Lakeville. It's a good thing they don't need CRMC approval.
These are fun. I'm not sure about this. I bought them at Greenland upon
Yeah, but I mean, they're zinc. They're supposed to, zinc is what you take when you take it in the cold.
And I got them at Holland today.
Oh, and it's been awful the last couple of weeks. It doesn't, because I think it shakes it out of the trees.
Okay.
I know, I go out like Ryan, and I cough for days.
Okay. All right, guys, we're going to continue on. The board is back in session so that we can continue. I do want to ask Jamie and also legal counsel, because we are running into a deadline whereby the applicant has not given us any additional time for an additional meeting, which means that we need to be able to make a decision by June 1st. And there is talk about having a special meeting on May 30th. However, with this excellent turnout tonight from the public, is there a way in which we can accept any sort of written testimony if we close the public hearing and continue our meeting to May 30th? And I know, Peter, you just caught the very end of
But,
that.
Madam Chair, again, not representing myself as legal counsel, but from a planning perspective.
Yes.
If you close the public hearing and you receive additional testimony, no one's allowed to rebut or respond to that information. So I would be conservative, in my opinion to you, that once you close the public hearing, that is the record you need to make your decision on.
Peter, I was expressing my concern with the fact that we have this June 1st deadline and potentially a meeting, a special meeting on May 30th, and want to be able to be sure that we get all the public comments.
And
And is there a mechanism by which
Madam
we
Chair,
can somehow do this without?
just before Peter responds to that,
Yep.
if the applicant wants to submit additional testimony, they can consent to an extension of time. They're the one who gave you the deadline of June 1st.
They are.
So my recommendation, hearing what I've heard tonight, would be after you hear the testimony tonight, to close the public hearing. We've already recommended that you hold a special meeting on May 30th, which is the 5th Tuesday of the month, and that meeting would be purposeful in your deliberations and drafting of a motion.
Yes.
So, and actually, Madam Chair, I'd just be probably even more conservative than Jamie on this, because there was a recent Superior Court case where a planning board approval for a solar field in Cranston was overturned because certain comment was received after the public comment period was closed, and the abutters and the applicants didn't have a chance to comment on that. So, if you were to take anything in writing, you would have to almost keep the public hearing open so that then they could comment on that.
Okay, thank you. All right, folks, I would come right up to the microphone, state your name for the record.
Good evening, Madam Chair, board members. My name's Jennifer Cervenka. I represent the Wakefield Meadows Condominium Association. I was here before you at your last regular meeting on April 25th. As you know, we are an abutting property owner. We're 142 residential units for 55 and older community members. We have submitted correspondence to the board previously, a petition from the association early on, and then 2 letters from myself on behalf of the association. I primarily had raised procedural issues in moving forward with this application. The first most fundamental procedural defect is that the development includes the development of 2 lots and an access way that is owned by the association. That is Land Unit 1 of our condominium development association. There's an access easement that provides them access, but we are the fee owner. According to your subdivision and development regulations, all fee owners involved, all fee owners of lots involved in the development must have a written authorization. So that must be, in our view, part of your packet to make this a complete application. We have not been asked for authorization to include Hampton Way, over which there's an access easement, but we are the fee owner. You don't have a written authorization before you. The second defect, procedural defect, which I spoke about at your April 25th meeting, in 2006, as part of our own development's permitting history, this board required that the association provide access for the build-out of District 5. And at the time, in 2006, as a matter of public record, the approved land uses were for light industrial, commercial, and specifically no residential. And we believe that it would be prejudicial to the association to now allow for a changed use that could overburden that access easement. We have expressed to the applicant's team that we believe that this will be an unreasonable use of our access easement. And without proper evidence presented before this board, we don't believe that they can demonstrate that there will not be a health and safety impact upon the association members. At a minimum, we would like this board to ensure that the traffic study is updated. The one that was referenced tonight, I believe it was a 2018 original report. I have a June 2017 traffic study report. I think that's the same thing. But in any event, that traffic study relies upon traffic counts going back to 2015. That's almost a decade ago that there were traffic counts collected on the affected intersections. That is just a stale baseline upon which to render any conclusions. We don't challenge the methodology of how you go about performing a traffic study. It's just the data is old and stale. There's an updated report. It just talks about the difference between a restaurant use and a residential use. That's needed also. We have some issues with that, but fundamentally, it's that old, stale data. And once that data is updated, we believe that if there's any approval here, that should be a condition of the approval. We would like an evaluation of mitigating techniques that could be implemented if there are, and we believe that it will show significant impacts. Again, almost a decade ago is the baseline data. That's just insufficient. Besides the procedural issues, I just want to talk about the legal standard under the comprehensive permit that you're charged with enforcing and applying tonight or on the 30th. One of the elements is that you must make a positive finding, and I'm going to read from it, that there's no, quote, significant impacts on the health and safety of current residents. That is the association. That is mostly everyone in this room that will be impacted by this. I have the quote, intensity and density. That came from Mr. Bronk's mouth. That's how he's described this project, intensity and density. And we have not heard any testimony about how this applicant is going to mitigate any impacts upon this association, upon the use of Hampton Way, which we own and which we maintain. We're obligated to maintain Hampton Way, so we incur expenses for its use. So our residents would like this board to condition any approval that this board may give for master plan to address the following. First, safety. We would like specific measures to prevent the residents of the new facility from trespassing in our private property. They're entitled through their access easement to use it for access, ingress and egress by car or by foot to their project area, not to pass through our property. We heard a lot of discussions about what are the alternative means to get to places where you can shop and dine, and a natural access point is through our neighborhood. It is private property. We do not want to open up our private property to intensity and density and an overburdened residential facility. The residents would like there to be signage that would be placed on Hampton Way that would indicate that it's private property, that there cannot be parking. We heard about parking this evening. Is it enough? Is there really shared parking? We don't know. Is it going to be overburdened? Are they going to be deficient? If there's a restaurant that's put in at a later time that needs 50 spaces, the access easement does not allow for parking on Hampton Way. It's ingress and egress by foot or by vehicle, not parking. We would also like there to address buffering and landscaping between the new project and our association property. There's discussion in, I believe, the response to the TRC comments by the applicant that there's sufficient buffering from the scenic highway. There's nothing that addresses the abutters, even though the concern from the TRC was both Route 1 scenic highway and the abutters. Throughout this process, there has not been any attempt to address concerns of this southern abutter. We had a meeting with the full team. I've had, follow-up discussions with the applicant. I've never gotten a response of what could be done to mitigate potential impacts on the association property. And they have an affirmative burden to demonstrate under the comprehensive permit that they will not have a negative adverse impact on us. Under your Route 1 Special Management District ordinance, it provides, quote, "The board may require additional screening, landscaping, or buffering, the purpose of which is to mitigate any adverse impacts upon existing adjacent residential property." That's section 605.8. We would also like, as I've discussed earlier, mitigative measures to be implemented to address traffic impacts, which we believe an updated traffic study will show, a traffic study with counts from 2023. Under the Special Management District Ordinance 60520, that is also an area that this board has authority to require. I want to point out, just read from this traffic study. Again, I believe it's June 2017 as opposed to 2018. Is that correct, Attorney Landry? There's not a separate, there's only one, right? Original study. This one.
Yeah, it's the one that we submitted it as part of the
Okay. This is from page 6. Again, it's talking about the baseline traffic counts. It says the manual turning movement count at the intersection of Route 1 with the Government Center Hampton Way was collected on June 2015 as part of a recent traffic study for a development project by Deprete Engineering. Okay, so from 2015 and for a separate project, not this project. And then it also talks about the growth between 2015 and going back to 1998. So this is, I mean, it's astounding how old and dated the conclusions are in this original study. Again, it was supplemented, but not as to its baseline. It also makes reference in its operational analysis to a 2010 highway capacity manual, and that was the methodology that they used for how this is going to operate. And just doing a Google search this afternoon, I see that there's a 2023 highway capacity manual that exists that could be used, which I think would be more relevant to this application. There was some discussion about the RIDOT and the, whether or not you could get a pedestrian path on the scenic highway. And I just wanted to reference recent experience that I had before the scenic Roadway Board, which is a state board. And I'm not familiar with the ordinance the town has here, if they have an ordinance on it. But I have had my experience with the Scenic Roadway Board, and it was on a very simple project that didn't involve any curb cuts, that was arguably not within their jurisdiction, and it took 6 months, and they're very, very particular. That's a entirely, different path that I don't think this applicant can make, any suggestions that they would get any sort of approvals given at least the experience I went through with this board. So again, this board has the authority through both the special management, Route 1 Special Management District Ordinance, and its own authorities under the subdivision regulations to require mitigation and to protect abutting property owners. And we would urge this board to exercise these powers if it is so inclined to grant a master plan approval, even though we don't believe that it should because of the procedural defects. But if it moves beyond that and grants the approval, we would like there to be the conditions that I just mentioned to ensure the health and safety of these residents are protected, and part of the future studies, the traffic study update, and a specific mitigation plan that the applicant should be required to produce to this board as far as buffering, traffic, parking, safety. So those are my attorney comments. There are some members of the association that have been waiting to speak for quite a long time on this project. We have asked that the members keep their comments as concise as possible, to relate to their personal knowledge to the extent they can, and if they agree with someone, just to mention they agree with someone, and hopefully we can move through this quickly, but I do think it's important to hear from the members outside of my attorney comments. So with that, I think, Rick Wilson, would you like to be the first to speak? Okay. Thank you for your time.
I just have a quick question.
So, yes, so before Mr. Wilson speaks.
So, one of the first things you said was the procedural error, and that our subdivision regulations require that the owner of the property grant approval or that they receive written approval from the owner. Why wouldn't the easement or the deed restriction constitute written notice?
As we've noted, we believe that this is an overburdening of the easement. So there's actual a legal dispute as to whether or not they would be properly using this. And your subdivision regulations do not specify, there's no exceptions. It just says any of the lots involved in the development require written authorization from the fee owners, from the lot owners. And that is our Unit 1 of our condominium association property.
The easement does, or the deed restriction does grant authority for pedestrians and vehicle traffic to cross over that piece of property to access where the development site is.
It does. It provides for ingress and egress by foot or by vehicle. And again, I will relate you back to our permitting in 2006, that we were required by this board to provide that access easement for a full build-out of District 5 that contemplated at the time that it would be light industrial, commercial, and specifically not residential.
So your position is that there was written notice provided, but that it didn't...
Involved in the development, and there's no written authorization from us. And then also that it would be prejudicial to us because this board required us to provide this access for this build-out that was supposed to be something different than they now want to make it into. And given the intensity and density of this project, we believe that it's going to be an overburdening and unreasonable use of the access easement. That's a standard in Rhode Island law under case law. You cannot unreasonably use an access easement.
Okay, thank you.
Thank you.
Let me just follow up quickly
Sure.
with staff. Is that our rule or is that not our rule? All fee owners must provide written authorization.
So,
Is that a requirement of the towns? And if so, it sounds like a sticky point.
I'll answer that as a planner, and then legal will correct me if I misspeak. From our review of the application, there is an existing easement recorded in South Kingstown's land records, which gives an entity the rights to pass and repass for vehicular, pedestrian, and actually includes utilities. The developer has not proposed any improvements on that right-of-way, has not proposed to utilize that right-of-way. So it's potential a legal argument with regards to the validity of that easement. We've alluded to multiple uses that were associated with the 1998 approval. As a planner, I do not think this is a stretch as a professional. A 4-story office complex, which would be allowed in the 1998 plan, would have far greater traffic implications at 4 stories of offices than a 70-unit apartment complex. So there are some uses that we're contemplating in 1998 that potentially could have a far greater impact on an easement that was recorded with no restrictions. I think as a planner, if someone intended to record an easement, and I've been involved in a number of those over 34 years, that those restrictions would have been recorded with the easement. We are recording this easement and given the rights to pass and repass for said uses as identified in District 5's approved plans. It's from my view as a planner, it's unrestricted. I've been involved in land use applications where the references were mule teams and wagons. And courts have equated that to the largest commercial vehicle in the 1800s is equivalent, that 6-team mule and wagon team was equivalent to a tractor trailer in today's modern times. So I think with regards to that discussion, it may be an argument for a higher authority to make judgment on, but from a planning perspective, the applicant has provided an easement which gives them right to utilize that traveled way, and their development proposal at this time does not propose any improvements to that. Now, if there's discussions of, well, we're going to build a sidewalk from our development, if their plan included a recommendation to build a sidewalk from their apartment complex to Route 1, I would probably have a different opinion, because they are now proposing improvements on lands they don't own that would make it part of the development proposal. Similar to my discussion earlier, that they are proposing to take something away from a vetted, documented, recorded land use that they're telling you isn't subject to this application tonight. If they're saying that, then they also, someone can't argue the other. There are no proposed improvements other than the applicant's asserted testimony as stated tonight, as well as in the documentation, that they're only utilizing the right-of-way, proposing no other utilitarian purposes for that. They're not proposing parking. They're not proposing improvements. So I think in the end it becomes a question of law, potentially decided by the courts.
Thank you, Madam Chair. So that there is a requirement in the subdivision regulations that an owner sign an authorization form, and that's the term used, owner. So owning an easement is an ownership interest. It's not a fee ownership interest, but the subdivision regulations don't use the word fee. My opinion would be the abutters could have a case for overburdening an easement, but that is a civil matter and outside the jurisdiction of the board to decide. Of course, you can, if it bears on your consideration of traffic or other things that you have before you, you can consider it. But, legally, whether or not this is outside the scope of the easement and therefore they're essentially committing a trespass beyond their ownership, that's something that a court would have to decide.
But there is a standard of law and there is case law relevant to this unreasonable use of an access easement.
There is, and, it all depends on the intent and scope of the easement document and whether or not the use would fall within that or not.
Thanks.
And again, I'll go back to my original testimony that this isn't an easement that was granted to a development that had 3 single-family homes proposed for it. This is an easement granted to the entire District 5 land area, which included a school, which included other uses, that only excluded residential, but included some potentially intense, dense development that had implications on traffic, in my opinion, far beyond a 70-unit apartment complex.
So the only other thing I would add just on the, whether or not written authorization would be required, and as legal counsel pointed out, an easement holder has an ownership type interest of sorts. It is a legal right, right? So if you equate them as an owner, then you still have another owner. You have a co-owner of the same property. And if you have joint tenants on a property that you're seeking to subdivide, you need both of their signatures. So I would just put that back that, if they are an owner, we are also an owner with a written authorization required of us also. Thank you.
Mr. Wilson.
Thank you. Rick Wilson, I'm the treasurer for Wakefield Meadows on the board. And I seem to remember they were discussing walking around Route 1. I think the state passed a law that it was illegal to walk along a 4-lane divided highway. You can't walk on the Newport Bridge, you can't walk on the Jamestown Bridge, and I think it's illegal. So I think you'd have to look into that, but that removed the state from the liability of something happening on that road. That's the reason they passed that law.
Thanks.
Good evening. My name is Dave Catanzaro. I live at Wakefield Meadows. I have a couple of questions, quick ones. Is Wakefield Meadows part of South County Commons? Is that a district or something? It is.
It's within the same zoning district, it's within the Route 1 special
Right.
district, but it's not part of the South County Commons development.
Okay, all right, great. I needed to know that. Hang on one second. So, we barely even mentioned Wakefield Meadows tonight. All the discussion has been about South County Commons. And yet, in my opinion, not professional, South County Commons will have virtually no impact from this at all. They can't see it. There's going to be no road or path, whatever, to get to it. So the group affected by this are my neighbors at Wakefield Meadows. So I'm wondering, do these guys have to take care of the road? Do they have to provide finances to maintain the road, plow the road, fix it when there's holes in it? What are the responsibilities, us versus them, in taking care of the road? Because that's going to be a lot more traffic, as you guys have said. The other thing I wanted to know, and I'm going to be very direct, can these guys step over you, go right to the state, and get this thing approved? Because that's the rumor on the street.
Not at this point, but the legislation session has not yet ended. But most of the changes appear to be things that will be enacted at the earliest January 2024. But I can't,
You can't speak to that.
no, because.
Okay, so
we don't know what's-
what is the
So at this point in time, we are the authority that would approve or deny this application.
and why would that change?
Madam Chair, just a point from
And it's already in
administrative
process as well.
matters. The intent and purpose of tonight's hearing is to receive comments from the applicant, abutters, and any other one wishing to speak. If we can have the individuals coming to the mic pose their questions, we may have a simple answer, but we'll keep track of the questions and we'll attempt to answer them,
Right.
either as staff or give the applicant the opportunity to respond. But the
I
intent
don't
of
know what the point of
intent
your
the intent
is.
of this hearing is not to have a discussion between the public, staff, or the board. You're here to make comments and testify.
I have no idea what you're talking about.
But his
Can they
question
step,
is,
can these guys step over you and get this project
So
approved?
in essence is
We
we've received your
don't-
comments and someone will potentially address that.
but Peter, I think it's relevant. It's a procedural question, and it's, do you have a comment on this?
Well, would you like me to comment about the
Yes.
SHAP process?
Yes.
Okay. So this is an application that was filed under a particular state law that because they're proposing to provide 25% deed-restricted units to what's referred to as low to moderate income housing, if it is denied by this board, they can't skip the board. They have to get a decision. But if it's denied, they have the right to appeal to the State Housing Appeals Board, which is a state agency, which
That steps over you.
they would then review our decision pursuant to certain standards they have. Legal counsel would argue in front of the board, but they would potentially have the authority to overturn the board's decision.
That's all. Thank you very, very much. One more question, if I can remember it, and I can't. Sorry, guys. I had one more. Oh, I know what it is. What's going to happen June 1st?
June 1st is the deadline by which time this board has to make a decision because the applicant has not granted us any additional time for an additional meeting. Our normal meeting would fall beyond that time.
How did June 1st become the date?
It's not within our level of control, unfortunately. They have not agreed to any kind of modification of date. So that means that if you were here for the last meeting, we were somewhat dismayed by the fact that we need to have a special meeting, which would theoretically occur on May 30th, in which to finalize and vote on a decision.
And if a decision was not reached by June 1st, what would happen then?
We have to make a decision. That's a statutory time frame that we have to.
All right. Thank you very, very much for your time. I appreciate it.
Anyone else who wishes to speak, come right up to the mic.
I'm Anna Maria Verzi. I live at 148 Hampton Way. And there's been a lot of talk about people using bikes and walking. I'm all for that. I'm a bicyclist, my husband's a walker, and I also love mass transit. The challenge here, as you've pointed out, is the shortest, there there is a lack of mass transit. I'd love to see more, but there's a lack. And the shortest distance between 2 points, as we know, is this proposed development and from the downtown bus stop and the mall is private property at Wakefield Meadows, Hampton Way precisely. So if and when there is unauthorized access through our complex with 142 units, people over 55 and older, there's going to be increased likelihood of accidents and mishaps. A lot of our parking in our complex, you have to back out. So if someone's walking, in the wrong side of the street, again, unauthorized, I think it was referred to as trespassing, but they might not know the rules or that we're there backing up and not looking both ways, because it is a quiet community that, I guess, bottom line is our safety and the safety of people coming through would be put at risk. Also, I know we did discuss this density, but based on the developer's architectural drawings, it would be like having a 4 to 5 deck cruise ship permanently docked at the community's north end. And with this current design, it's going to overshadow we're 2 stories, and the building would be 4 stories facing our complex, so it would be overshadowing our homes. So those are some of the challenges in addition to the parking that was discussed. So thank you for your consideration.
Thank you.
Good evening or good morning, whichever. My name is Bill Krupe. I live at 260 Hampton Way. I'd like to share an experience I had a couple months ago. I walk just about every day, take different routes. And a couple months ago, I took a walk, and I was walking near the Bradley School. And it's quiet there, it's tranquil. And one of the teachers said, he says, "Sir, if you could turn around, I just brought this student." And I said, "Sure." He says, "I just brought this student out to try and calm him down from the school." And I said, "Sure, I got it." I walk away, and for the next 10 minutes, I got called everything under the sun from this kid. I mean, the point is that this school is there for a purpose, for its tranquility, its location. Our attorney a moment ago said our health and safety. The board should consider the factor of the Bradley School, its location, its proximity to the proposal, because if it's going to affect our health and safety as senior citizens, it's also going to affect the safety and health and the goal and objectivity of what the Bradley School is there for. Thank you.
I'm short. Good evening. My name is Martin Rosenzweig. I'm on the Wakefield Meadows board. And there seems to be one word that was thrown out 50 times tonight: amended. It seems like everything on this project has to be amended. Is it total disregard to what the original master plan was? Is there no law in effect? It seems like whatever they want to do, they want to disregard that and write a new master plan in their own image. That master plan was put in effect for a reason. And they totally want to disregard the reason. They just want to do what they want to do when they want to do it. With total disregard to the letter of the law, the original master plan. To take the honest truth, there's no basis for it. It was put there for a reason. Now they just want to throw it out, rip it up, throw it out. I really have to say that, you know, it takes a lot of nerve to want to do that. Just total disregard to what the law is. Thank you.
Thank you.
My name is Gil Fletcher. I live in Wakefield Meadows, and I have nothing to say. I just want an excuse to get out of my chair. Seriously. This project is not the right project for that undeveloped property. I'm not sure what is. But it's too big. And with all due respect to the experts that testified tonight, it's going to generate a lot of problems, parking problems, traffic problems. And if I lost confidence in Mr. Bronk's testimony when he said that the project was compatible with the site. And if I remember correctly, from the January meeting, the applicant was looking for 7 waivers. 7. And yet, the expert says that the project is compatible with the site. It's not. It's incompatible. But I know that they're compensated for their opinions.
Thank you.
Good evening. My name is Norma Owens. I'm the secretary of the Wakefield Meadows Association Board, and I'm also a resident at 133 Camden Court. I kind of like numbers, and I read the 2006 or 8 easement document, and it mentioned in that document that Suffolk LLC paid Pulte, which is now us, $5,000 for the easement and for maintenance forever, I guess, of the easement. And I also happen to know that we have a more current easement that was created with the Westerly Credit Union because they wanted to have access on the Kelly Way. And I was just trying to think as I sat here what multiple difference there is between the $5,000 that Pulte received and the amount of money that Westerly Credit Union paid us for the current easement. Is it 40 times as much? It's not 100 times as much, but it's a whole lot. It's like thousands and thousands of dollars more, tens of thousands of dollars more. So I don't really know what was going on in 2006. I don't really think it's all the differences due to inflation, but it just strikes me as untoward that an easement was granted for $5,000 when the current rates for such a thing are so much more, cost so much more money. Thank you.
Thank you. Hi, Gail Robinson. I live at 48 Camden Court. Just a couple of real quick things. One, I have a bike, an e-bike that I just got, and mostly because there's nowhere to go around there, I ride around our block, and around our block, and around our block, and around our block. And I have tried going out there and said, you know, it would be really, really nice to be able to get to over there to the South County Commons, but you drive up there to Route 1 and it's like, nah, I'm not doing that. So where do I go? I go and I drive over through the little parking lot that actually belongs to the hotel. And then I drive over the little circle that's in front of the Bradley School, and some man comes out, very nice man, and he comes and he tells me, please don't do that. He was very nice, but the school is there, the apartments will be there, and that's, I don't know, that's a 2-minute walk, 30-second walk, and they didn't want me riding in their little round circle there around the school.
because it would disturb children. And the man was very nice about it, so I left. So now I don't do my little trek anymore. So I don't know how you're going to separate that, but it is a concern. That's it.
Thank you.
Good evening, everyone. John Reiner, 131 West Wind Road. I've been a land use planner for over 20 years. I'm not being compensated for my opinion tonight. In all the years I've been doing this, I've never heard an abutter say that a development next to them is right-sized or the right thing. I don't envy the position that all of you are in, because not a lot of people like development, they don't like change, but the only constant in our lives is change. It's what's allowed us to evolve as a species. I've lived in this town for 20 years, over half of my life. We need more multifamily housing. We need more 1 and 2 bedroom units. This is an area in town that has water, it has sewer, it has access to a limited access highway. This is where we want development to happen. This is the exact place where density should go. That's why the Route 1 village plan and the zoning was put in place back in the late 90s, looking at what that's going to be. And over time, those plans evolve and change. Again, that statement about the only constant is change. And unfortunately, people in our existing villages in Wakefield and Peacedale and Kingston, they don't want a lot of new density either. So we have to figure out where is it going to go in town. We have an affordable housing plan. We haven't been doing a very good job of implementing that plan. Our affordable housing numbers are pretty meager and weak for what we've done over the past 20 years. So I think as a town, we have to think about doing that. I've heard a lot of talk about biking and walking tonight. I don't think too many people walked to tonight's meeting, unfortunately. We live in an automobile, maybe Paul did, but we live in an automobile-centric community, unfortunately. Those of us that are lucky enough to live in Peacedale or Wakefield, Kingston area, we can walk around a bit, but we still have our cars we have to depend on. But we do need housing and development that is addressing all of our mixed housing needs, our affordable housing, and our different market rate bedroom count. So I implore you to approve the development. Thank you.
Thank you.
My name is Ann Colby. I've lived in Wakefield Meadows, be 10 years in September. Something you might not know, each unit, 142 units, has 4 parking spaces. We have 2 overflow parking lots for visitors. And there is still problems with parking on the streets because we don't have sidewalks. We just have little berms, and the roads are narrow. So whenever there's any kind of improvements or painting, papering, any kind of anything happening, and there's extra vehicles there, where are they going in this other place? Who's doing the maintenance? How can they? I looked at the printout that was sent to all of us, and I counted all the spaces that they allocated around, and there's 89. I don't know what they're telling you, but count them. No overflow parking. Where are these people? How are they coming, going, getting to where? I think the project is too big. If they really feel this way, that they need this housing, I agree. But they need to think about the people that are going to live there and how they're going to get there and how they're going to survive, and not have it be difficult for them in their house. And even if they did have alternate parking, are they going to be parking 2 blocks away from where they want to walk into their house in the winter, in the snow, in the rain, in whatever? Nobody wants that. So there's not enough consideration for the people that are going to be living there, let alone for us who are buffered to it. Anyway, a lot to think about. Thank you.
Thank you.
Good evening. I'm Linda Harris. I live at 5 Camden Court. I'm right on the corner of Hamden Way and Camden Court. And my front windows face that corner, and I have a bird's eye view of everything that's going on. Already, we have a lot of people trespassing who are staying at the hotel. They're coming and walking through our complex. There are baby carriages on the roads that, are, as I said, are narrow. A lot of people, in a group, 4 and 5 people sometimes come through. And we do have a sign up that says private property, but it's totally disregarded. And I think with this housing and people looking for a place to walk, it's going to be even more dangerous and more people coming through. Thanks.
Pat Quinn, live at 148 Hampton Way. I just had a question for the developer. How many spaces are for handicap?
I think it's 6. It's whatever is required.
Mr. Landry, could you just use the microphone so that?
Give me a moment, I can verify that for you. It's 5 ADA spaces are required and 5 are provided. 5 are required by law and 5 are being provided.
Okay. And are there, are the apartments handicapped?
Could you just address your questions to the board, and then we
and-
can ask all the questions first, and then we'll try to get the answers for you.
Okay. And how many of those apartments are for handicap?
I can say that it'll comply with ADA requirements. Whatever the handicap accessible requirements are for this building will comply, but the specifics of which I can't give you the exact numbers now, but it'll comply with what we're required to provide.
And what provisions are made for service vehicles?
So once again, could you just get all your questions out at once, and
They're
then
just
we'll let
coming
him
to me at
respond?
once, but they're in that line. As I think about parking,
Okay.
how many of, if you're going to have service vehicles coming to the units, where are they going to park? And delivery, but they'll probably just pull up, but is there going to be parking set aside if people have to have Cool Co. come in and do something, or something has to be done in their apartment?
In terms of service vehicles, if I'm not sure if you mean van accessible spaces, those will be per the requirements, what we're required to provide, we will provide under the ADA. In terms of service vehicles, there's ample parking available. To the extent we're required to have a service or loading zone, we'll meet those requirements. But I'm not sure if I understand your question. There'll be parking available for any service vehicles that are needed or servicing the site.
Where are they going to park? Where is that figure? Okay, I'm sorry. Where would they park when they get there? And if residents are there, where is this parking going to be? That, say you get 3 people that call somebody and they're going to be there, and again, is there enough parking for people that are going to be living there and service vehicles being called?
I may defer to my professionals that did the site plan, but what I can say, the town typically has requirements for loading zones or service areas, and to the extent we need to comply with that, we will. I don't know if staff can comment on the specifics of what is required under that, but we haven't asked for a waiver from that, so.
And what about trash pickup? Where will the receptacle be located? And how often will trash be picked up for a 70-unit apartment building?
So we're getting to very, very detailed.
I was just going to say that some of these questions are
Well,
kind
let me
of
just
beyond
say, let me just say, it's very
conceptual
detailed, but
master
if you have a huge trash thing wherever they put this, because let me just say, nothing has been, or very little has been presented that has actual details of what they're doing here, and it's just kind of cavalier and disingenuous, I have to say, excuse me. But these are things that, once we're there, and there's a big dumpster or two that's going to, in an area where there's a lot of rodents and animals, that it's going to attract, that is going to be right in our neighborhood. Where is this trash going to be? How is it going to be picked up? When's it going to be picked up? Because it might be detailed, but, or there might be, I might be hypothetical here, but there's going to be trash, and it's going to be right next to our place, and I want to know, when's it going to be picked up and how often?
So those kind of details, just as you could probably tell that the board is often tempted to ask some of the more detailed questions related to that kind of thing, stormwater, but generally, since this is conceptual master plan, we don't always get those answers until preliminary because they have not yet defined them.
Okay.
Even though we might want to ask those questions, and we often do, they can't always answer them.
Okay, but those are
We
just...
will get them at preliminary if it moves forward to that stage.
Okay, great. Those are just some of the things I thought about with the parking, you know, practical issues. When you live in a place like that, there's going to be service, there's going to be trash, and the trash could end up right next to our place, because I didn't see any requirements for trees or any kind of buffers. But like you
Landscaping.
said, that'll come in later.
Landscaping.
Thanks a lot. Thanks for your patience.
You're welcome.
My name is Bill Allman. I live in Wakefield Meadows. And the last meeting, it was pointed out to me that when the extra parking, when there's too many cars for this development, which there will be, in my opinion, they're going to be parking on our road, And I was told that we would get no help with that from the police because it's a private road. So I'm just wondering about not only parking, but the other things that are going to happen if this project gets approved. With that many people, with, as I think this, one of the board members pointed out, they're going to want to go right through our property. And that's going to not put aspersions on people who are going to be renting in this place, but there's going to be a lot of litter. There's just going to be a lot of consideration that should be given to us for that place. I mean, these people, they're greedy, I think, trying to put 70 units in this little piece of land that's over there, you know, and other people have pointed out they make a lot of gestures about how it looks from Route 1, but how is this going to look for the people that live close there? They're going to have like a 5-story building facing them with, you know, who knows what people on the balconies and all this kind of things. But the main thing is just too many people for that size area. And I just don't understand why, well, I kind of do understand why they don't make something smaller to provide enough parking. It's just greed. There's no need to make for 70 units, you know? And if they're all that altruistic, why don't they go somewhere where there's public transportation, there's sidewalks, and they build some affordable housing for people instead of, you know, just the profit. If you multiply what they'll probably be getting from rents, even though some are affordable, we're talking a lot of money, gross, million. And that's the whole reason, in my opinion, that they're trying to get that many units in there is just profit, okay? No, thank you for your time.
Thank you.
Yeah.
Good evening. My name is Tom Madonna.
and I own a unit at Wakefield Meadows. And I was just sitting, listening to everyone, and I was just thinking about the parking issue and the waivers that they're looking for 1.5 spaces per unit. And that will accommodate, as they said, all of the people that will be renting there. One thing I think we're forgetting is all the people that will be invited there by the people that are renting there. And that could be an enormous amount of parking, additional parking needed. I'm just thinking of 4 kids renting an apartment from URI, and they decide they're going to have a party, and they invite 5 kids, and 5 more cars come over, and all of a sudden that one unit is probably looking at 9 or 10 cars. So I think we have to also take into consideration not only the amount of spaces necessary to accommodate the renters, but we need to consider some conceptual idea of how many spaces will actually be needed when people are invited to visit. Thank you.
Thank you.
Good evening, and thank you for your patience and on so many levels, because I know your staff reviewed this project and they came up with a lot of their own concerns.
Could you just state your name first, please?
Patricia Rye, sorry. Patricia Rye, I live in Wakefield Meadows. And they had a number of concerns that whenever I've come to these meetings, they're never addressed. Concerns your own staff brought forward to this project, like it's too big, there are too many units. And this developer comes in and they've never addressed them. And so I think you're very patient in letting them continue to move forward with this without addressing any of your own staff concerns. Also, I just wanted to say that, you know, they're riding on the backs of affordable housing here. It's not going to make a difference in the percentage of affordable housing in this county, in this area. It's not going to change the percentage available at all. There's so many other options that could be considered. I know there's a huge lot behind an existing housing unit in Peacedale that hasn't been developed, and it has transportation. I think everything else has really been said about walkability. There is none. About storm runoff, we're already overburdened in our storm system in Wakefield Meadows. You know, I do want to point also that they brought up the census, and that census did include URI students because it's done in April and they're still in residence. I think we live in a unique community because of URI, and students are always looking for housing. There'd be a lot more affordable housing, frankly, if those units that go to students, the private houses, were available to families. So just those thoughts. You know, I don't want to mention parking again. But these things, I think, are concerns of mine, and I know my community. So thank you for your time.
Thank you.
I'm Dean Kosaka, Wakefield Meadows. I just want to emphasize one thing to everyone, that safety. This Wakefield Meadows has absolutely no sidewalks. Everyone walks on the street, and that's basically the only way pedestrians can operate in Wakefield Meadows. Therefore, an overabundance of cars or people, that just increases the potential for a serious accident. And most of the people there are like myself, 55 or older. So I just would want you to keep that in mind in your decision making. Thank you.
Thank you.
Dorothy Daniels, I'm at Wakefield Meadows too. And when I saw the size and the structure that's being proposed, I couldn't help but think about COVID. You know, we saw what happened to our nursing homes, our assisted living homes, facilities with COVID, how it wreaked havoc there. And now we're proposing a residential structure, a single structure, long corridors, a single entrance point, a lot of shared spaces like we had in nursing homes. The nursing homes had high density of people and a lot of shared spaces, and so does this proposed project. You're going to have shared spaces in your elevators, your stairways, and your corridors, and your entranceway. So the next time we have a COVID coming through, which might have a different name, just think what's going to happen in this structure. We're duplicating what went on in the nursing homes. I'm surprised at this day and age that we're even looking at a structure like this without smaller units, less shared space to take care of the potential for COVID in the future, which is not an if, it's a when. And think about what's going to happen in this structure. So I think strongly, because of what we have learned from COVID, we should not be building this kind of structure with crowded density, 5 stories high, shared ventilation systems. And given what we know about COVID, we should be building smaller units and less shared space. So for the health of the whole of South Kingstown, I think that needs to be part of your deliberation. Thank you.
Thank you. Is there anyone else who wishes to speak tonight? Board members? Thoughts prior to closing the public hearing? We can also obviously discuss after the public hearing has been closed.
Madam Chair, we have a few follow-up questions, if we may.
Thank you, Madam Chair. If I could, I'd just like to try to clarify with the applicant's counsel the applicant's position with regard to this application and how would it affect the existing District 5 plan. So, because I'm still not clear on what their position is, and I just want to make sure I'm clear on what their position is. So I've broken it down into a couple of just yes or no questions. And the first one is, do you agree that the planning board may approve this application on the condition that the existing District 5 plan, which includes Assessor's Plat 50-4, Lot 22, Lot 25, and Lot 26, the condition that that be amended at a later stage of review?
Lot 22, 26, and 25?
Yes.
We believe, well, no, I need to quantify this. We do agree that there could be a condition to amend the master plan, the preliminary plan as to these lots.
All 3 of them?
Well, we're not waiving that third restaurant site, and it's not part of this application, but to the extent that the preliminary plan needs to be amended to reflect any approvals as to these two lots, then I would agree.
Just to clarify, I'm not asking you to waive anything. I'm just asking, do you agree that the planning board can grant on a condition that the District 5 plan be amended, and that includes all 3 lots?
As long as that amendment is consistent with this approval, this master plan approval.
I don't think you're answering the question.
I'm not sure I'm understanding it. That there's a change to these 2 lots that is being proposed, a master plan, that is different than what is currently approved, the preliminary plan. So I agree that an amendment would be needed to the preliminary plan to the extent of these 2 lots. So it would include that restaurant site, but we're not waiving that restaurant site. So that the amendment would only be as to whatever needs to be done that's consistent with this approval.
I think there's a difference between what the planning board's authority might be versus what your preference might be. Am I?
Yeah, I guess that's what I guess, you know, to boil it down to, obviously, I know you don't want to give up anything. No applicant would come up here and willingly say, we want to give up something. But I'm just asking, you know, I think we're in agreement that it's going to have to require an amendment to the District 5 plan, which already exists. And that plan involves 3 lots. I know that your application is only with 2 of those 3 lots.
Mhm.
But do you agree that as an approval, or is it your position that when they approve this, they can do it on the condition that the District 5 plan will be amended, which includes those 3 lots?
Yes, I would agree to a condition that it would require an amendment to the preliminary plan.
Okay.
That includes the 3 lots.
The existing preliminary plan approval.
So, and you'd agree that any subsequent amendment to the District 5 plan, well, I guess I asked that, would involve all 3 parcels in the District 5 plan, and that the separate ownership of those 3 parcels wouldn't prevent the planning board from doing that?
Well, I mean, in order to file an application for preliminary plan, all the lots proposed for development would need to be made part of that application. So it's a procedural issue for preliminary plan.
And each 3 of them would have to file at that stage. Is that your position?
When we file the preliminary plan amendment, the lots that are proposed for amendment would have to include all the owners.
Just to clarify, that's 22, 25, and 26.
And if the amendment pertains to those 3 lots, then yes.
So, just for clarity, you're saying no. You're saying your preliminary plan amendment application will only include the lots you're proposing development on. And if it doesn't include development on the restaurant pad, it will not be subject to that application.
Well, put it this way, whatever lots are subject to the preliminary plan application are subject to the amendment to the preliminary plan.
And so the preliminary plan is 22, 25, and 26. So if the condition is you need to amend the existing District 5 plan, when you come back, it would be for 22, 25, and 26?
I mean, I can't, as long as it's a reasonable condition, I mean,
reasonable conditions, you can always appeal and challenge conditions, say they're not reasonable. I'm just asking about the lots involved when they come back. You'd apply 22, 25, and 26.
There needs to be an amendment to the existing preliminary plan, and the lots that need to be included there, we will include them on the application.
Which are 22, 25, and 26?
Those are the lots that are on the preliminary plan approval currently.
Okay, yes. So those lots will be included. Last point, you agree that if the planning board would approve this approval, they could place conditions on this approval about the type of amendments they would want to see at the subsequently amended District 5 plan.
Sorry, I don't, if you have to repeat that.
So
I'm sorry,
I'll
I
give you
don't
an
understand.
example just to illustrate. They could place a condition on this approval that anticipates you'll be coming forward to amend the District 5 plan, and they could say, and on that amended District 5 plan, we want to see X, Y, Z. You agree they could place a condition like that?
They can impose reasonable conditions to this approval.
Assuming, every condition would have to assume to be reasonable, and we could debate what conditions are reasonable. I just want to clarify, a condition could have, you have to amend the District 5 plan, which includes Lot 22, Lot 25, 26, and we want to see these conditions on that amended plan. Now, assuming they're reasonable, and we can debate that, but assume for a second that they are, you agree the planning board could do that?
I mean, we're getting into hypotheticals, so I think, based on your advice to the board, you can advise them to impose the conditions you think they can reasonably. As long as they're reasonable conditions, I don't have an objection to that.
Okay.
Just,
And we're not concerned that the definition of reasonable may be highly subjective here.
Well, that's a standard that,
Yeah, I mean, I could assume any condition they aren't going to agree with, they'd say is unreasonable.
Perspective.
I just wanted to say, in theory, what we're doing here, if we were to say, if you were to approve it, saying, the condition is you have to amend the District 5 plan when you come back, which would include an application with those 3 lots, and conditions could be placed on that, and then the debate would be, is it a reasonable condition? But that process is a process that, I'm just trying to make sure we're in agreement on the process going forward, not whether or not conditions are reasonable or should be imposed, just the process.
and again, Madam Chair, Jamie Rabbit, Mr. Landry alluded to the term hypothetical, but to potentially put a little more realistic application to that hypothetical scenario, if you're conditioned to approve this application included a condition that the applicant increase the buffer requirements, which right now are nothing along Route 1, on their preliminary application between Route 1 and the parking associated with the hotel and restaurant, you're asking them to improve something on land that is part of the original development, but not part of this application. That would be a real-life scenario where you would condition a requirement that additional landscaping or screening be placed between Route 1 and the existing hotel parking.
And so just to use that as an example, the question would be, is your position that the planning board has the authority to do that, even though it would require that buffering to go on a lot that's not currently in this application?
yeah, I'm not sure I've ever seen that before. I mean, the board only has jurisdiction to place conditions on the lots that are subject to the
Well,
application.
let me use an even, another, I think, more on point, or something that would directly go to the heart of this. The 3 lots in the District 5 plan were approved all at once as a group of uses. Let's say there's drainage calculations and drainage plans that affect all 3 uses together. Now, let's assume that those drainage calculations need to be amended when the uses are amended. Could the planning board say, we want you to amend the District 5 plan when you come back, but the drainage calculations need to be redone using the new use, and make sure that the drainage is okay for all the lots in the District 5 plan?
Yeah, I mean, we're proposing a use where the drainage has to work and be consistent with the existing, yeah.
Do you agree that they could impose that type of a condition, even though it includes that 3rd lot, which is not here? So just for a process perspective.
Yeah, from a process perspective, I think a better way to say it is that the board can impose reasonable conditions that are consistent with this master plan approval,
So
to effectuate the master plan approval.
just using that hypothetical, but if I want to put a point on it, just beyond just a reasonable condition, let's say that the change to the drainage plan requires you to change grading on lot 25, which is the lot that's not currently in the application. Requires you to do something on that lot. It's part of the overall approval to the District 5 plan. Is that something that you think the planning board could impose?
I mean, again, it depends, if those systems are being impacted or changed on lot 25, at the next stage, we've got to submit an application that shows modifications to drainage and anything else. So I would say, to the extent that it's necessary, I mean, I suppose it could be a condition.
So it could include Lot 25, and that's only the point I wanted to get at. Could it include Lot 25 from your perspective?
I mean, again, they can impose reasonable conditions that relate to this master plan approval. Whether or not a higher power thinks that that's legal or
Just
not.
yes or no, could it include Lot 25? That's the only point.
If it relates to the systems that we're proposing, yes.
Okay.
That's a yes.
If it relates.
If it, you know, again, I mean, what I'm afraid of is a condition to include something for Lot 25 that we don't need because it's not necessary for the preliminary plan application. You know what I'm saying? I don't think the board has the authority to require us to do something that's not necessary.
I guess it would be yes, if it's addressed to an impact from your new proposed use.
If it's addressed to?
An impact from your new proposed use.
I suppose, yeah.
Okay.
Or a result of something you're taking away from an approved use.
Well, again, we've got to, if there's a modification to the existing preliminary plan that includes changes to parking or anything impacting that third use, we would have to include it as part of the application.
Okay. I mean, that's kind of what I was driving at.
I mean, if it needs to be changed or modified, then we have to include it as part of the application. I guess that the problem I don't want to run into is a condition that I guess would be unreasonable, that it requires us to include a lot that we don't have to include because it's not proposed to change. You know, I don't want to get into a corner where we have to include a lot just because.
I don't think, Mr. Landry, anyone's trying to put the applicant in a corner. It's just you have a proposal before the planning board right now that eliminates 50 parking spaces for a restaurant that has an approval for it. So if you come back at the preliminary plan and you show the hotel parked and you show the apartment complex parked, and then there's no parking left for the restaurant, then the restaurant can't exist. So when you come back for preliminary, if there are 3 proposed uses that have valid approvals on that site, you're going to need to park all 3 uses.
Understood.
Or adjust.
No,
It
understood.
may mean a smaller apartment complex. You can't make a smaller hotel. And you can have whomever you want testify that they only need so many parking. But to me, that's contractual based on the specific vendor within that hotel, and that changes over time. So what the Hyatt needs versus the Hilton needs versus the Marriott needs versus another entity, that's not contemplated. Commissions and boards are approving permits for property, not permits for specific entities who occupy the property. So whether it's an Applebee's or a Chili's, you know, you could argue one has less parking demand than the other, but you're parking a restaurant. So all we're saying is, when you come back potentially, to please understand that the hotel is going to have parking requirements, your apartment is going to have parking requirements, and that additional use that has final approval on, other than an architecture, if it's still there in any shape, way, or form, you're going to have to park it.
And they're all parked as, you know, that was approved as a group and it's all.
No, I understand. No, I know what you're getting. I understand that. To the extent those 3 uses impact one another and that they're on a plan, we understand that if there's an impact to that, we have to include them.
Matt, I apologize, I've been dying to ask.
That's okay.
You've explained, I'm sorry, Jay Parker, Principal Planner, South Kingstown. You've explained before that you felt that in your world or your opinion that to submit you wouldn't necessarily submit an amendment to a master plan. You'd submit a new master plan.
You submit a new, yeah.
Right?
That's right, yeah.
So in this instance, the District 5 master plan was approved as with all 8 districts at the same time. It's gone through the process. We've gone through preliminary and all that. Now you're coming back saying, oh, we want to go back and we want to amend just District 5, just that. We're not going to amend it. In my world, you said it's a new master plan, right?
Yeah, and what I would equate that to is there has been an amendments to the South County Commons Master Plan, the 98 Master Plan, for specific buildings, specific lots in this development, and those amendments were made to this board that allowed an otherwise restricted use to be utilized, no different than what we're doing.
I understand.
So that's all, but in our world, and what they did in that case here before the board was they filed for an amendment It was not a comp permit, it was commercial use, but they filed an amendment to the 98 master plan because there was a restriction on the use. It wasn't allowed. So they came before the board, and that, it was a new master plan. They came in, it was amended, it was allowed, and, you know, there was a lot of other issues going on in that, but the procedural process was a new master plan and an amendment that was specifically limited to that building and that lot. And that's all we're asking for here.
I understand. My question is, why wouldn't that same process apply to your preliminary stance? Why wouldn't you just apply for a new preliminary plan? However, you are indicating that you are going to amend the preliminary plan. So I'm having a hard time figuring out what's the difference between conceptual master plan and preliminary.
Well, way different stages of engineering and, you know, the level of detail. But I would say, and I think I've said this before, that if that restriction didn't exist, the no residential uses on the 98 master plan, we would have come in straight for preliminary, an amended preliminary, if you will, for this use. Because there was that restriction, we had to come back to master plan to relieve that restriction. And that's why we came in with the new master plan.
So in our world, in the planner's world, would be considered an amendment to a previously approved plan, or a change to a previously approved plan, not a new plan. A new plan just seems to confuse the issue. And to me, who's sitting back looking at just the process, I only really care about the process, because as a planner, that's all we have.
Sure.
That's all we can go by state law. That's all we're given. So looking at the process, it doesn't make sense to me why we would, I use this term like 6 times today, mixing our peas and carrots and calling one the other and holding a different process. It almost seems like we're trying to pick and choose what we're going to consider and what we're not, when the original approval, the original decision didn't just look at those in silos, it looked at the whole thing. So I'm just having a hard time trying to understand why a conceptual process, the conceptual master plan process in your eyes, would be different than the preliminary in that regard. Why wouldn't you just...
Well, just to take that example of the prior amendment, you have the South County Commons master plan that was approved in various districts with proposed or intended uses for those various districts. The entity came in and said, I'm not allowed to have this use in this building, in this district, because it's not allowed in the district and it's not allowed in the master plan. They came in with a new master plan. They didn't come in with a new preliminary. They came in with a new master plan because they needed to amend that restriction. And you can't go straight to preliminary and undo that restriction if it exists on master plan. You can't jump over that process.
I think it's just a plan, how we approach it. To me, it would just be an amendment or a change to a previously approved plan, no matter if it's preliminary or conceptual master. It just follows the bouncing ball. But I think that's what leads to my difficulty in trying to understand the process and trying to apply the same standards at each stage. It just...
No, and I appreciate that. I know this is a unique situation that's odd because you've got an old approval, but it is a change in use and it's a new plan. I mean, if you've got a traditional plan that was approved, commercial property, and you're changing the uses around, you've got to present a new master plan because the whole concept is different than what was originally approved. And we've acknowledged it. That's why we can't. I mean, it would have been a lot easier to just come to preliminary and do that and skip this step. But we acknowledge, and that's why we submitted a master plan under the comp permit statute.
Madam Chair, we won't belabor the point, but I think what Jay's struggling with is this isn't a new master plan for District 5. This is a new master plan for 2 of the uses within District 5. And the difference between the other amendments within the districts north is that those amendments for a particular use within the approved master plan only had implications on that one building, one use, and didn't affect the other uses within the development. The difficulty we're struggling here on process is that we use the term cherry-picked, that they are cherry-picking 2 uses within 3 for fear that the discussion involving all 3 has implications on the overall development viability of the entire district. And I'll end there. I just want to make just a statement, General, based on a couple of comments tonight. And that is, as a professional planner, I agree with the majority of the comments tonight regarding the fact that the town of South Kingstown needs more affordable housing. I think that doesn't need to be debated. But what should be noted is that South Kingstown's effort should not be looked at in isolation. Historic public policy and market conditions have led us to where we are today. And other municipalities in Rhode Island, are no better off than SK, and some of these towns may surprise you. Municipalities like Central Falls have less affordable housing today percentage-wise than they did in 2005. Pawtucket, Providence, North Providence, Warwick, Charleston, and Narragansett are no better on their equating and bringing affordable housing to the marketplace. This is not a South Kingstown issue. This is public policy. These are market conditions that in some instances are 100% outside the control of legislation or at the state level or at the local level. This town probably has in excess of 500 single-family existing vacant lots. If each one of those has one house built on it, that's going to be 500 new single-family homes, not a single one of them affordable. That is not because of any policy that the state of Rhode Island passed. That's not because of any regulatory aspect that the town of South Kingstown has adopted. Those are due to market conditions, and as Landry would defend and our attorney would defend, people have rights to develop their property under the regulations
Property rights
before
as well
them.
as market conditions, yes.
So, to single out South Kingstown as not forwarding their affordable housing initiatives and plans, I think if you single out South Kingstown, you have to single out places like Groton, Stonington, places in Connecticut. I've been a planner there in my past endeavors for 32 years. It's no different in Massachusetts. It's no different in Washington State, Colorado, Oregon. Everyone's trying to solve the problem. No one has a direct answer to that problem. With regards to some of the testimony tonight, what concerns me is when professionals try to call something one thing when it's actually another. Planners have a tendency to explain how a development fits within a particular regulatory space when actually that recognition should just be simple. It doesn't conform to that regulatory space that has been planned for after years of public input and associated with successful planning and permitting. You got to call it what it is. No one is against change, but it is important to point out that people are accustomed to planned growth, and unfortunately, the comprehensive permit process allows development to occur outside that norm. This apartment complex, in my professional view, is not infill development. It's not the redevelopment of anything. It's certainly not a village with an apartment complex connected to a hotel with a restaurant isolated from the community, isolated from South County Commons. Let's just call it what it is. It's a 70-unit apartment complex being proposed in a community that doesn't have 10% as legislated by Rhode Island, and the applicant has a right under the comprehensive permit process to propose this development. But from my sitting here as your planning director, I just struggle with the fact that, and I applaud Mr. Brock's presentation tonight. He was thrown into this. He did his best to articulate what Ed Pimentel intended. But Brock, by his own admission, he read Ed's report. Ed is masterful at taking a sentence within a paragraph, taking a word within the sentence, but not adding the paragraph before or the paragraph after, the word before, the word after, the sentence before, the sentence after. So when you talk about centric village design, right after it names the villages in the town, none of which are this property. So to say it's walkable, it's bikeable, it's public transit orientated is just not right. This is a 70-unit apartment complex, and the planning board has to determine on the comprehensive permit process, not whether you like it, not whether it fits, whether it meets the needs and contentions under the findings borne by the legislation adopted by the state of Rhode Island. If it can be parked, if it works, you should approve it. But if it doesn't work, if it's underparked, if the uses aren't cohesive and revisions need to be made, you should make those findings also. But again, I don't want to belabor the opinion. This is not a village. It's a component of a southern parcel of land that was developed, and as Mr. Bronk or Ed actually read the original development plans for South County Commons, it actually opines on the fact that this parcel, District 5, is isolated from the entire South County Commons project, and because of that isolation, was treated differently. So to call it part of the village, the own plan that the planners, developers, and original designers stated that there was a disconnect. So I don't know how today, 20 plus years after the process, you undo all that wonderful planning that we've alluded to and say there's now a connection. To me as a planner, this is relatively simple. It's a 70-unit apartment complex proposed where a restaurant used to be, next to a hotel, next to a vetted, approved second restaurant, and we need to determine how it fits, and if you feel it doesn't fit now, what conditions do you need to place on the application so that you feel it is compatible and does fit and does work? And
Thanks, Jamie. We do need a motion to continue past 11 o'clock. Would someone like to make that motion?
So moved.
Motion from Joe. Second? Second, we need a motion to continue the meeting after 11. Second from Susan. Any further discussion? All those in favor say aye.
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 So yes, we have not yet closed the public hearing. Is there anything else from staff or from planning board members?
Again, Madam Chair, I had a number of questions for Mr. Pimental. I do not feel that Mr. Brock is in the position to answer those questions, so professionally, I don't want to call him back and ask him to answer questions that I think Ed
Minute. So
Pimental-
folks who are leaving, we will be reconvening our meeting, although it is unlikely to be a public hearing on May 30th, which is next Tuesday?
Tuesday.
And that's when we'll be making our final decision.
Public hearing, you can come, you just can't.
But yes, you can attend, you just can't make comments because we'll be closing the public hearing tonight due to the time constraints imposed by the applicant.
The only other comment I would like to make is, under the discussion tonight about the type of development, 1 bedroom versus 2 bedroom, and 1 bedroom doesn't have kids and 2 bedrooms don't have kids, or I think the term was used that the report concluded that small units almost generate no children. That's referenced on page 78 of the town's comprehensive community plan, and it's reference to generating that. There's a study done in 2020 by Harvard University's Graduate School of Design and the Harvard Kennedy School that contemplates Americans' rental housing in the year 2020. And it was actually determined that that conclusion is potentially debunked. And in fact, that they determined that a number of married couples with children and their home ownership fell by 2.7 million between 2004 and 2018. And the number of rentals rose by 680,000, reflecting that the rising age of renters and delays in home buying. These changes have meant that families and children are now making up a larger share of rental households, 29%, than owner households, 26%. Consequently, the demand for households with children is more relevant than in the past. So there are changes in the housing dynamics, and it may have been that, in fact, 20 years ago, that home ownership and family raising was the norm. But because of the marketplace and conditions to enter into a single-family home has placed additional burdens on the rental aspect. I would trust that Harvard did a well in-depth study. I've read the 100-plus page document and kind of agree with their conclusions, because that's what we're seeing. In a community that has high entry levels to single-family home ownership, the only option potentially from an affordability standpoint for families to enter that community and put their kids in the school system is the rental market. There is also, and it was mentioned tonight about divorces, there are a lot of single parents with children who can live in 1- and 2-bedroom apartments, that this is part of that market share, and this is what the Harvard study talked about.
So Jamie, can I ask you a question about this? Are you talking about the affordable units or all the units?
All units. So if this is 100%.
We don't have any restrictions in this to keep this from being seasonal rentals. So it may not even be families, it may be seasonal, yes?
What the applicant has proposed right now is a 100% rental property with 25%, I believe it equates to 18 units, affordable.
The
7
rental
units
doesn't
total.
necessarily need to be annual.
I think, as council has advised you tonight, that is potentially a reasonable condition that could be placed. I'm not sure from an enforcement standpoint how you monitor that.
Yeah,
enforce.
actually, there's a state law that was enacted with regard to short-term rentals through online platforms like Airbnb, and municipalities are actually prohibited from preventing dwelling units from being rented on a short-term basis on those types of platforms. So I don't think you could put a condition that would prevent the units from being rented short-term like that.
So this may not satisfy any of our needs for family rental units,
I'm sorry.
except for the affordable units.
I have a question. You said that the town could not impose. Could the developer voluntarily agree to restrict leases to a minimum, say, 12 months?
I think you could. I think to make it enforceable, you'd have to record some type of restrictive covenant. And then the question would be, who would be responsible for enforcing that, which would be difficult.
I understand there are enforcement issues, but as Susan brought up, one of our big problems in the town in terms of not just housing affordability, but making housing available to residents is trying to find some kind of mechanism to keep housing from falling into the academic seasonal rotation that prevents regular full-time people from finding a home in South Kingstown, and those are the people. We need to work certain jobs. I have members of our economic development committee complaining to me constantly about how there's employers who can't find employees because there are not options for those people to live in the area. So if that would be a considerable help if the developer would agree to do something like that.
And generally, to address that concern, municipalities can pass zoning ordinances that prohibit more than 3 unrelated people living together. The town does have that, which you can get around it by getting a special use permit from the zoning board. But again, it's difficult to enforce because even if there's more than 3 people in the unit, you have to prove that they're not related. And if they say they're related, there's really not much you can do to contradict that.
Right, and these are 1- and 2-bedroom units. So that may not even be a 3-person, 4-person problem, you know?
Right. I think in short-term rentals, you probably would be, because I think a lot of times you'll pack multiple people into 1-bedroom unit for a short-term rental, but probably not for a longer term.
If there are no further comments or questions, would someone like to make a motion to close the public hearing?
So can we talk about the wisdom?
What?
So if we close the public hearing, we can't ask any more questions of the developer. The people can't write to us, we can't respond, like, we're done? There's no more answering of any questions or any?
So, Madam Chair, just to clarify Ms. Axelrod's question, once the public hearing is closed, you have the record that you may make a decision on. The public cannot reach out to individual commission members. The public can't send written testimony to the planning department. If we receive written testimony, it will go in a sealed envelope and marked received after the close of the public hearing. It will be kept as in the file, but it will not be read by staff, and it will not be distributed to the planning board. The applicant has given you until June 1st. We're sitting here tonight on May 23rd. So you have this Wednesday, Thursday, Friday, Monday's a holiday, Tuesday, and Wednesday is the last night you could meet. We had made recommendations that next Tuesday is the 5th Tuesday of the month. So there typically isn't a planned meeting that night. Again, if there's no further public testimony this evening, our recommendation would be to close the public hearing portion. The planning board would decide on what is in the record. You have access to staff. Staff can review and comment on what's in the record. So staff will continue to review the testimony from this evening and then advise the commission based on that testimony.
And Jamie, from the beginning of this process, the board has had questions and had suggestions for the applicant as a way of potential negotiation to modify the project to make it better. But those attempts have essentially been in vain. So with the public hearing closed, we no longer have the ability to ask for changes to the plan. Is that correct?
I think that's right, because any revised plan submitted by the applicant would
open up a
the
public hearing again,
yeah.
right?
So you can impose conditions
Yep.
to change it,
Yep.
but that would be based on your decision.
Right. Could you just need to restate your name for the record?
If the public, Thomas Madonna,
Yep.
if the public hearing is not yet closed, may I ask a question?
You may.
Thank you. So, listening to this whole thing tonight, I'm just thinking, and I know this has been going on for months, but in a sense, aren't we putting the cart before the horse? Shouldn't the master plan be amended first so you know what you're dealing with in terms of what they're asking for, rather than granting, if you do so desire to grant a certain portion or all of this petition, and then seek to have a master plan amended? Shouldn't it have been or required to be amended first, so you got a foundation where you know you go forward from there? But suppose the master plan cannot get amended. Suppose there are, Wakefield, I think, will have to sign off on that. Suppose we're part of it, suppose we don't want to sign off on the master plan. Seems as though this is all a big waste of time. It's my opinion.
So the conversation with regard to amendment of the master plan has come up several times this evening, as well as the expression of the cart before the horse. I do not believe that Wakefield Meadows is in any kind of position of authority with regard to amending the master plan. They can comment on it, but they're not the decision makers per se. However, I think that's why the back and forth has occurred about new master plan versus amending the previous master plan, and that was definitely an issue that was confusing. Jay brought it up, Jamie brought it up.
Madam Chair, if I can just...
Perhaps
I'll try and solidify an answer. The applicant has proposed a certain application process. The planning board will evaluate that after the public hearing is closed and make a determination of whether they think that application process was sufficient and all that was needed. And that will be determined at a future date.
I'm just thinking that Wakefield Meadows is the fee owner of the easemented area. And I think as a fee owner, we would be required, or we have to make a comment, yay or nay, on an amendment to the master plan.
That point was made tonight. It's part of the public record, and that will be, I'm sure, part of the discussion and deliberations by the planning board.
And I think that even Mr. Landry mentioned this evening that the master plan has to be amended. And all I'm saying is, I think Wakefield Meadows, as a fee owner, has a say in that.
It's my
And
understanding.
I think it's
from what legal
unanimous. I think
counsel
every
said-
free owner of that, within that master plan, has to agree. Otherwise, it cannot be amended. I think it has to be 100%.
I'll leave that up to legal counsel to answer
So,
that.
you know, I guess the way I would look at it is that the subdivision regulations require the owner authorization to file. The applicant does have an ownership interest in the easement. Now, the question is, because the condominium association owns the fee, does that require them to be part of the application? You know, if the subdivision regulations were interpreted in that way, it could give the condominium association a veto right over something that they've already granted through the easement, which is the right of access. So I understand the argument. It's something that we'll have to address. But I think the way to look at that would be, we know they have a right of access through the easement, which is an ownership interest that allows them ingress and egress. And if there's an issue as far as overburdening the easement, that's an issue that would have to be resolved in a civil matter. That could be a lawsuit between Hampton Way and the applicant.
I just think that in consideration of the reliance that Wakefield Meadows had at the time that they agreed to give the easement, gives us the right today to assent or not assent to a change in the master plan, in addition to the fact that we are the fee owner.
I think you're getting into legal areas that we don't necessarily have jurisdiction over.
I understand, but I just wanted to put it on the record.
Thank you.
You're welcome.
Go ahead.
So following this thought, who does need to sign off on a change of master plan for South County Commons?
So, from my perspective, the public hearing purpose is to receive comments and testimony. You have an opinion from abutters. You have an opinion from the applicant's legal counsel. And after the public hearing is closed and when you are deliberating, legal counsel will weigh in on that. To our legal counsel's point this evening, that may not be able to be resolved outside of this process and may be part of civil action post-decision. Counsel will guide you as you deliberate.
Any other questions or thoughts? That said, would someone like to make a motion to close the public hearing?
I'll make the motion to close the public hearing.
We have a motion from Joe. Do we have a second?
I'll second it.
Second from Liz. Is there further discussion? Hearing none, all those in favor say aye.
Aye.
Aye. Motion carries. So Jamie, what do you need from us at this point?
So, Madam Chair, with regards to this subject matter, it would be our intent to schedule a special meeting for May 30th, Tuesday night, to start at 7 o'clock unless the planning board would like to start earlier. It is one day after a holiday, but we will work at your pleasure. And we could do a doodle poll with you with regards to whether it's 6 or 6:30 or 7. But again, the chair can call a special meeting and we will set the agenda. The only thing I would mention is we have one small minor amendment to a previously approved plan associated with Magnolia Lane. You talked about it briefly at the workshop where they're proposing to slightly adjust the driveway to the existing 2 duplexes that are under construction. That discussion should be brief and will be fully vetted by staff with a recommendation to you. So although it's a special meeting, primary purpose of deciding on South County Commons District 5 application, we would also ask that you add that one additional agenda item.
And you can assure us that it's not going to be anything complex?
It should not be complex.
Checking.
There's a conflict with the installation of a transformer box and the underground utilities. They need to adjust the driveway 15 to 20 feet to the southeast, and they have added landscaping to that relocation on both the southeast side and northeast side of the proposed road.
Jamie, why can't that wait till the next meeting?
Again, we're trying to move this through the, trying to move things through the process. This should be a 5-minute discussion. I will speak for less than 5 minutes. I can't account for the questions the board may have. Yes, I can. Planners struggle.
All right, and what else do you need from the board?
If you would like it, given the very nature of the subject matter discussed tonight with this agenda item, if you feel appropriate to entertain a motion to hold a special meeting on May 30th on Tuesday night, final time to be determined.
I think,
Do we need a motion to do that, or?
yeah, I think just, I think probably it would be best if it works for the board to put it at 7, just so when you continue it, everybody who was available can be here. And, or, yeah.
Not a continuation of the public hearing. It's a special meeting.
So who would like to make that motion?
Before we make that motion, I guess I see that this project, regardless of which way the board goes, is probably going to be litigated to the next level. And I think, I know it's late, but it may be appropriate for us to see where the board members stand, and if they are so inclined to approve it, what their conditions, maybe what some of the conditions would be, or if they're inclined to disapprove it, what their reasoning is, just so that staff would have a good feeling for where the board is and perhaps could start working on a draft motion that would allow us to look at it at the special meeting and hopefully clean it up to a little more. And I know
Madam
it's
Chair.
late, but I just think that, given our time constraints,
Mr. Murphy makes a good point. Staff is prepared to develop motions, potentially based on your discussion this evening, but we're really prepared to draft 2 motions.
That's precisely.
One in a favorable manner and one in a non-favorable manner. We would attempt to distribute that, I want to say Friday, but there's a chance it may come to you Saturday, based on what we have to put together based on the record. But our intent would be to have that to you so you would be able to look at it over the weekend. Again, it is a holiday weekend, to be prepared to fully discuss the items on Tuesday. So I think based on your questioning over time, as well as the public comment and the applicant's presentation, I want to say I think our team has a fairly good understanding of what the issues are and what the requirements on the comprehensive permit are.
But certainly, Joe, if you would like to speak to your concerns.
I will. I know it's late. I mean, truthfully, to me, there's so many issues here, and they're so interlocked that I might have a hard time staying coherent, but I'll try my best. I think one of the issues that does not sit well with me is the whole idea of changing the master plan when residents have purchased property and have a reasonable expectation that that master plan would be followed, where the applicant himself should not have an expectation at all that they can put in residential when that master plan doesn't show that. I don't know what the standard is from a legal perspective for us to change that, and even if it's, and beyond that, I don't know what the standard is, that even if it was legal, what would be appropriate for us to change that. So that's a concern. I do think that as a minimum, to be appropriate to change that, I'd have to understand completely what the concerns are of, and the potential impacts to the neighboring property owners, and making sure that those impacts are either not significant or can be mitigated to something less than significant through conditions of approval. I am not there yet as far as changing of the master plan, because there seems that there will be some impacts as far as people passing through not having enough parking and potential trespassing onto that. So if we look at the master plan, I'm not quite there that it's appropriate to change the master plan when they had reasonable expectations that the residential wouldn't be there. And then beyond that, once we get into the structure itself, I have concerns about the parking. Those were talked about over and over again. I have concerns about the demographics and that we're not serving the appropriate demographics, be that we're only tailoring to couples or elderly when there's demographics that throughout the town that in need of housing. The parking, the demographics, all that is being driven by the size and the density and the number of units. If there wasn't as many units, we could have more recreational area, we could tailor to, we could have more parking, we could tailor to other demographics. I will say that, and I know Mr. Landry is an excellent attorney. He's been in front of this board several times. He does a great job representing his client. He doesn't have a choice. However, there's been, in my opinion, a lot of disregard for the planning board, for the community, and for the neighbors. When this came in front of us for a preliminary, we tried to gently steer them to something that was smaller, something that would not create all these problems. There was total disregard for any comments that was received at that level. The fact that we are being pushed now without being able to adequately address this, I think that is disregard for potential impacts to the neighbors, to take the position that they're gonna change the master plan, they're gonna use the road for something else. I think that is that's disregard for, again, the neighboring property owners. So I'm gonna have a hard time getting there, both on the master plan and on this. I think it could have all been avoided, but unfortunately, I think Mr. Landry is the applicant. Again, in my 8 years, this is probably the project that stands out with the most disregard for the community.
Thanks, Joe. I could not have put it any better. I agree with everything that Joe said. Anybody else wish to say anything at this point in time? I see some heads nodding.
I do.
Go ahead.
I mean, as far as things that I would be looking for toward an approval, as I said earlier, I think just some record of a discussion with DOT and Scenic Roadways about the potential for a pathway along Route 1. It may not be possible, I understand that, but I would like to see the discussion happen. You know, some sort of just a draft sketch, preliminary plan that people can look at. You know, again, there's one small wetland edge that needs to be skirted. I don't know if that qualifies as a wetland crossing or not, but, and I think just as far as the neighbors, landscaping, fencing, you know, landscaping, you know, we all have to look at development, but if there's something we can do within reason to shield the existing neighborhood, fencing to keep people out. We know it's going to be a problem. It unfortunately, you know, isn't going to be our problem. And the 12-month rentals, I realize it sounds like we can't require that. The applicant volunteering to do it, to me, is a real sweetener.
Thanks. Paul, anybody else? Susan?
I don't have much to say yet because I need to spend some time getting my thoughts together. But I agree with both Paul and Joe and some of the comments they've made. And I think for me, one of the problems that's left this sour is that this project is the exact same project we saw way back in the beginning. And we've asked for things to make this better for the community. And it seems almost in a belligerent, nope, not changing a thing. We haven't gotten community space, we haven't gotten recreation space, we haven't gotten any concessions on height or mass or density or landscaping or any of the small concessions we were hoping for. They've offered us no concessions in any way from all of our requests to make this a better project for us. And no offense, but it seems arrogant to have just powered this through and just, it's all or nothing. They're not willing to give us any love here. And then there's also some comments like, we're going to hear about shared parking after this is approved. And we're going to hear about landscaping after it's approved. And we're going to hear about open space and recreation space and, I don't know, pedestrian walkways. It's dotted lines showing where the parking spaces are. Like, you've given us nothing, and you're saying you'll get it at preliminary. It would have been sweet to see some of it now, so I know more of what I'm signing up for. And something really alarmed me tonight, which is Mr. Landry's horror at the idea of losing the second restaurant, which seems to me a given that you cannot park this many cars on this lot. We're going to have to give up the restaurant, the one out front of the hotel. But that seems to be a non-starter for this group, and I'm like, I don't know, I'm just a little bit nervous about this, the idea that they're not giving up that restaurant. And that's not even negotiable. And I know that you've had a conversation later than that, but earlier tonight, that wasn't even on the table, and I'm a little bit concerned about that rigidity with this project. So that's my comments.
Thanks, Susan. Anyone else wish to share?
Madam Chair?
Yes.
Just briefly, just because the comment was made a couple of times about inflexibility on the part of the applicant with requests to modify. I won't speak again to this applicant's strategy, but I'll just kind of speak in generally that some applicants can take that position strategically with the understanding that they actually want to get the denial so they can appeal it to SHAB and hope that they can get whatever they want. Not saying anything that this would happen in this case, but one thing for the board to consider is that this could lead to a denial, or it could lead to an approval with the conditions that impose the modifications that you would have liked to see, but they were not willing to agree to. That way, it's a much different posture in appealing to SHAB with a straight denial as opposed to an approval with the conditions that impose those conditions that you think would make it a fit. So it's just something to consider as you move to the next meeting.
Thanks, Peter. If there are no further comments before we adjourn, we do need a volunteer for the TRC on June 14th. Is anyone available? Thank you, Paul. And if there's nothing else, would someone like to make a motion to adjourn?
So moved.
We have a motion from Joe, second from Susan.
Second.
Any further discussion? Hearing none, all those in favor say aye.
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 No.
Motion. Definitely too late. Thanks, everyone.
What are we at? 3.5.
I'd probably